Great pleasure to be here today. My name is Joel. I'm Joel Basoga. I'm very excited to be able to moderate this training on data protection and training, especially the opportunities for lawyers. I cannot overemphasize the significance of this conversation, particularly because data protection issues have become at the forefront of legal practice. I think that it would not be an overestimation to say that the same way the 70s and 80s were defined by the growth of intellectual property practice, the last 7 and 8 years and the next 30 years are going to be defined almost exclusively by data protection compliance. And I think that there are various risks associated with the use of data, and I believe that this makes this discussion inherently important. But by way of introduction, my name is Joel Basoga. I am the head of technology at H&G Advocates, and it is a distinct pleasure and honor for me to be here. Practicing data protection law is one of the most fulfilling experiences for me. And today we have a very well-organized training that has been planned meticulously with different distinguished speakers, starting from the principal regulator under the Municipal Data Protection and Privacy Act of Uganda, the acting director of the Personal Data Protection Office, Mr. Baker Birikuja, is going to be one of the speakers today. Specifically, he's going to give the keynote address that will set in tone the conversation and the training. And we will also have a discussion that will be led by Mr. Opio Isaac, and he's going to be discussing for us data protection compliance for law firms, specifically understanding and fulfilling legal obligations for client personal data protection. We'll also have Miss Barbara Among Arinda, who is the executive director of the Credit Reference Bureau Association of Uganda. She will be addressing us on data protection privacy, but specifically client support and business opportunities for lawyers. Again, because this training is organized under the auspices of the Uganda Law Society, it's important for lawyers to listen in and understand what is the role of the lawyer in this emerging legal practice area. And we'll also have Mr. Stephen Mugabe, who is Counsel, Mr. Arthur Isiko, to open this training. I'd just like to make a few remarks. Data privacy is now one of the singular, growing practice areas. And as I said, the same impact that the intellectual property law practice had in the 70s and 80s is the same wave by which data privacy is going to change how we conceptualize and even how we practice law. So to that extent, there are various risks associated with data, and some of those include the loss of financial information, which is sensitive data, the loss of health or biometric data, and all these risks in some way create legal obligations, and under the law, if one is prosecuted, they will create fines. And I think that sets the tone for our training today, and it is my honor, singular honor and pleasure to be able to invite the treasurer of the Uganda Law Society, the Honorable Arthur Isiko, who will make opening remarks before we proceed to hear the keynote on this training. Mr. Isiko, the Honorable Isiko, the floor is yours.
Yes, thank you so much, Mr. Joel Basoga. I hope I'm loud and clear.
Yes, we can hear you.
Yes, good morning, everyone. Good morning, honorable members of the Uganda Law Society, our distinguished facilitators, esteemed colleagues, and all participants who are joining in, both live and physically. Of course, today, the moderator, as you all heard, Mr. Joel Basoga is actually taking on the floor We have various speakers, Ms. Barbara Amonga Rinda, Mr. Stefan Mugabe, Mr. Opio Isaac, and of course we shall have the keynote speak for Mr. Baker Abariku. Let me take this opportunity to thank you, our speakers, for sparing time to train and equip participants to keep the lawyers with the latest insights on data protection and privacy. We welcome you to this pivotal training on data protection, compliance, and opportunities for law firms. It's a privilege to deliver these remarks as we embark on a journey to deepen our understanding of data protection laws and also explore various opportunities as they present themselves to the government practitioners. What I can say from my own personal perspective, this is one of the virgin areas that I can implore most lawyers to actually take advantage of. Most of the companies that are coming into the country are getting data from, personal data from so many people. And now it is a requirement that for any company to continue with such a transactional business where they actually have information concerning the citizens of this country, they need to get necessary documentation from the relevant authorities. So this gives us an opportunity to actually enlarge our areas of practice where we can actually milk and probably get a living as the practitioners of the paternity. So in 2019, Uganda took a significant step towards enacting the Data Protection and Privacy Act. I believe most lawyers took advantage and probably read the act. It was a landmark legislation that underscores our collective commitment to safeguard personal data and uphold the fundamental rights to privacy. This act, along with other accompanying regulations, provides a robust framework that governs the collection, processing, and storage of personal data within our jurisdiction. As legal professionals, we are not only custodians of the law, but also entrusted stewards of our clients' most sensitive information. Our role extends beyond compliance. We are champions of ethical data practices, advocates for transparency, leaders in fostering trust within the digital ecosystem. Today's training is designed to keep us with the knowledge and tools necessary to navigate the complexities of data protection. We'll have various critical areas where our moderators will actually take us through. One of them is the client support and business opportunities for lawyers. Yeah, this gives us an understanding how data protection compliance can enhance client relationships and also open new avenues for legal services. That is one of the areas in which our speakers will actually be elaborating. How can we lawyers actually support our clients? How can we as lawyers support the business opportunities that avail themselves in this area of data protection? So that will give us an understanding of the legal obligations for both the client and also for us as the lawyers in ensuring that we do provide our service. So the issue of understanding and giving legal obligations or enhancing the understanding of clients on their personal obligations towards the data protection, that is one of the areas that actually will be discussed by our speakers. It gives basically a comprehensive overview of the responsibilities under the Data Protection and Privacy Act. This includes giving the importance of informed consent, ensuring data accuracy, and then implementing the security safeguards. I think these are areas where our speakers will be elaborating and giving a clear understanding to the lawyers to actually understand this area better. They will also actually delve into the issue of cybersecurity for law firms. This explores the best practices for protecting our own data infrastructure and mitigating risks associated with cyber threats. Of course, as you know, even us as lawyers, we are client information. This training will actually ensure that it equips us with the best international practices on how we can avert any cyber risks associated with running our law firms. So as we engage in today's session, let's remember that data protection is not merely a legal requirement, but a moral imperative. It is a testament to our professionalism and our dedication to serving the best interests of our clients and society at large. I encourage each of you to actively participate, ask questions, share insights, and I believe together we can transform the challenges of data protection and also explore the various opportunities that will actually give growth not only to the nation, but to our practice as advocates, the innovation, the excellency that shall actually come with us embracing these practices that are going to be actually well elaborated. So at this juncture, I will not take much of the time, since I know this is the programmed event. I want to thank you, and I look forward to our collective learning and collaboration throughout this training. Thank you so much. I'll I think call upon the moderator to take it up from here. Thank you so much for listening to me. I hope you have a meaningful and a fruitful discussion.
Thank you. Thank you very much, the Honorable Arthur Isiko. It has been such a pleasure listening to you. I'm pleased with what you said about the increasing opportunities, especially for law firms. When new practice areas have come up previously, individuals have had to, get certifications, let's say intellectual property, they've gotten certifications with the Trademark Association, they've become patent attorneys, and I really think there are opportunities. But I also think that handling client information creates certain levels of risk. So thank you so much, the Honorable Arthur Isiko, for your remarks, who is the treasurer of the Uganda Law Society. Again, I'm certain that some of you have just joined us, and I'd like to welcome you to this training titled the Data Protection Compliance Training, Opportunities for Law Firms. We have a star-studded list of speakers that will begin with the Director of the Personal Data Protection Office, Mr. Baker Birikuja, who will give the keynote that is going to set the ball rolling, after which we're going to have 3 separate speakers who are going to address us specifically on 3 issues. The first will be Mr. Opio Isaac, following the keynote, who will address us on the compliance for law firms, understanding and fulfilling obligations for client personal data. After which we'll have Ms. Barbara Among Arinda, who will address us on client support and business opportunities for lawyers. And then we'll have Mr. Stephen Mugabe, who will address us for cybersecurity for law firms. And after those 3 presentations, which will follow the keynote of Mr. Birikuja, we will then have a panel discussion where we will address the questions of the audience. So if a presentation is ongoing, be it the keynote, please feel free to write your comments in the Q&A part of the chat. We are taking note of them, and when the panel discussion starts, we will be able to address your questions. Now, before I invite the acting director for the Personal Data Protection Office, I think it's very important for us to understand why data protection is important. Most organizations, even law firms, take a reactionary perspective to data protection. After there's been a major data security breach, or after they have been sued, or they've gotten a legal notice to sue from an employee whose image has been used without consent, that is when people begin to understand data protection. But I think we should move from reacting, we should move from being reactionary. We must understand the risks and the opportunities that data presents. And I think that data privacy is one of the singular areas of practices that has been moving over the last decade. For instance, just in East Africa, Kenya and Uganda, passed their laws in 2019. Then Rwanda and Tanzania followed in 2021 and 2022. And according to the United Nations Conference on Trade and Development, over 134 countries have passed data protection laws. What does that signal to you as a practitioner? I think one of the things that signals is that this is an area that is here to stay. And in fact, here in Uganda, as I line up to invite the acting director of the Personal Data Protection Office, who is the principal regulator? The Personal Data Protection Office is a corporate entity that is established under the law. And I think one of the most important things is that under that law, the fines that can be issued for failure to comply with data protection law can be up to 2% of the gross turnover for failure to comply with the Ugandan data privacy laws. And actually, there's been a number of decisions, one of them involving Nalubega versus Starbucks, where the High Court even made an order of general damages on account of the company's failure to obtain consent required under the data protection and privacy law. So this is a real area. We're not at the university speculating and discussing theoretical concepts. The courts have begun handling these issues, and this brings me to the introduction of the keynote speaker, Mr. Baker Birikuja, who is the acting director of the Personal Data Protection Office. Mr. Birikuja is a legal and compliance professional with more than 10 years experience, 5 of which are at senior management level, focused on information technology law, data protection, and cybersecurity. As the acting National Personal Data Protection Director, he oversees a nationwide strategy, coordination, and implementation of the Uganda's Data Protection and Privacy Act, CAP 97, or Chapter 97 of the revised edition of the laws of Uganda. Regionally and internationally, Baker advances data policy discourse through Global Privacy Assembly as International Enforcement Working Group, the Africa-Asia AI Policy Makers Network, the African Union Data Governance Committee, and the East African Community Data Protection Harmonization Technical Working Group. He also co-authored the Ugandan chapter of the Walters Kluwer's Privacy and Technology Law, edition of 2021. In terms of qualifications, Baker holds the IAAP's Certified Information Privacy Professional and the Certified Information Privacy Manager certifications, and is a Fellow of Information Privacy. He's earned a Bachelor of Laws degree from Uganda Christian University and a postgraduate diploma in legal practice from the Law Development Center, and a professional award in complaints handling and investigations from Bond Saloon. Now, as you have heard, as lawyers, one of my colleagues is a tax lawyer, and when the URA makes a statement, when they issue a publication, tax lawyers in Kampala study it closely. In a similar way, when the acting national director of the Personal Data Protection Office makes a remark, even if they cough, it is of interest to data protection lawyers. So please join with me in welcoming Mr. Birikuja, who will address us for the next 30 to 40 minutes, giving us a keynote to set the ball rolling on the theme, Data Protection Compliance Opportunities for Lawyers. Baker, you are most welcome.
Good morning. Thank you, Mr. Basoga, for that introduction. As already introduced, my name is Baker Birikuja, and today we are here to have a training on the data protection compliance and opportunities for law firms. The theme is timely. As advocates, we are fiduciaries of trust, and in today's digital economy, personal data is the new currency. While artificial intelligence is the engine increasingly powering its use and misuse, every brief that you may have either at your law firm or at your workplace, be it in chambers or legal departments, or the emails that could even have personal data, how you handle such carries with it responsibility as provided for in the law. But as lawyers, we are in a unique position, is that We are the people that guide other people. We advise them and even entities on what should be done. So today I'm speaking to you with two hats. One, as already introduced, the Acting National Personal Data Protection Director, being responsible for implementing the Data Protection and Privacy Act of Uganda, but also spearheading the implementation of national strategies on the same, including the National Development Plan 4 that is going to drive Uganda into becoming a tenfold economy. And data protection and privacy is recognized as one of the key areas. But I'm also a proud member of the Uganda Law Society, and I'm a member of the ICT cluster. So this conversation is very clear and key, that I'll be talking to you from a regulator's perspective, but also as a member from what we've been seeing. You'll bear with me, I'm a little bit under the weather, but hopefully you can hear me as we have this conversation. So today's message is clear. Compliance is key, and particularly with the different laws that we'll be delving into. But before we do that, let's look at the history of data protection and privacy in Uganda. In Uganda, before we even had anything to do with data protection and privacy, we had in 1948 the Universal Declaration of Human Rights that recognized the right to privacy as a human right that should be guaranteed to any person. Many countries started recognizing this right in their constitutions. In Uganda, this only happened in 1995, where under Article 27, it recognized such a right. But beyond 1995, not much was done. But between 2010 to 2016, so many other laws started coming up, looking at aspects of confidentiality, privacy, and data protection. This included the three laws that we call the cyber laws: Electronic Transactions Act, which talks about regulating and providing legal recognition of sorry. Hello, can you hear me? Sorry about that. So the three cyber laws: one which is about transacting online, giving it legal recognition, and electronic signatures, which recognizes electronic signatures and digital signatures as well, and the Computer Misuse Act that penalizes anyone that misuses such spaces. Those came from the East African Community 2008 cyber laws framework that required each country to put in place and implement laws that will support the digital economy. One of those areas that were not considered or enacted was the Data Protection and Privacy Act, because there wasn't enough expertise within the region and it was parked. But that changed, especially with the General Data Protection Regulation of EU in 2016 when it was enacted. But also now we had more people going online. Uganda caught up, following not just the East African Community 2008 Cyber Laws Framework, but also what is called the Malabo Convention, which is the African Union Cybersecurity and Personal Data Protection Convention. It requires each country within Africa to enact a data protection law and set up a regulator to implement it. Uganda did exactly that. The development took a while, started in 2015, and the law was enacted by passed by Parliament in 2018, where in 2019 the law was signed. The regulations came into force in 2021, some years later, that operationalized the regulator called the Personal Data Protection Office in August 2021. Many lawyers may read the Act and wonder, we are seeing the regulator being mentioned as NITAU, that is the National IT Authority, and yet when we are interacting with the regulated parties, we always talk about PDPO, which is the Personal Data Protection Office, and this is why. When the law was being prepared, benchmarking was done in other countries and even other frameworks that I've talked about, which required to have an independent regulator. Uganda couldn't have one because the Cabinet of Ministers had passed a moratorium not to create any more new agencies, and yet the law was needed. What made the law more pressing is that Uganda specifically had the business process outsourcing industry. At that time, what was most popular was where we had call centers, and young people could be able to take these calls and advise companies and their clients, companies which were not even in Uganda, on how they can get about their business. And in one of those areas were around mainly the professional services. But when the General Data Protection Regulation of EU came in, not much of that information could be sent to Uganda because we didn't have a regulatory framework that was comprehensive. So it became very critical that that law was enacted. So one of the reasons as to why the law was enacted was really to support that particular business area. And within that business area that is commonly known as BPO, there is what is also called KPO. KPO is about knowledge process outsourcing. It's where you have professional service providers such as auditors, accountants, and lawyers being able to provide services to clients that are not within that jurisdiction, which is Uganda. So this law was really created to enable business, and that's why we're talking about these business opportunities. As we all know, data cuts across borders. You don't need to have a law firm, let's say in Rwanda or Tanzania, or even in Eastern Europe for you to be able to provide that service. The beauty of data protection is that it's hinged on international principles which are really mirrored in Uganda's law, as long as you have that particular expertise. So beyond the law, we needed a strategic plan as the office to give us that direction on what we should focus on in implementing this law within the next 5 years. And last year, that strategic plan was launched, and that strategic plan talks about a number of areas that I believe you as lawyers, you should be interested in, because when you understand the direction the office is taking, then you can be able to position yourself on how you can tap into the opportunities. One is to operationalize the office. So, like I talked about, that elsewhere, the laws required and the treaties that you have an independent office. But in Uganda, we couldn't have one because of the cabinet decision. So what was put in place rather was to have an independent office within an existing office. That is NITAYU, the National IT Authority. And within NITAYU is PDPO, which is independent of NITA, its operations, and reports directly to the board. The national director is appointed by the minister, as it is with the ED, that is the executive director of NITAYU. So it created a semblance of independence that even NITAYU is one of the entities that are actually regulated by PDPO. So the law says that within NITAYU, PDPO shall be responsible for implementing the law. Because NITAYU is also guided on how to implement the law, they collect a lot of data, they have a national data center, develop systems for government, and then they also have what is called the systems integration that allows different government agencies to share and being granted access to the data by other agencies. So that is the unique nature, and within the strategic plan, it required that that office be operationalized, which is now in operation, coming to 4 years. Beyond the operationalizing of the office, the other was to create awareness. We've been creating awareness on social media, focus group discussions, broadcast media as well, and also print. But where we're invited, as it is with ULS today, we also take up that opportunity, because where we have data protection being talked about in most spaces, that means people will become more aware of it. In Uganda, it's very critical because a survey of 2022, it was conducted nationally, found that only 13% of Ugandans were even aware of this law. But what was even more concerning is that government, since government in Uganda collects the most data, many of them thought that the law doesn't apply to them. So beyond creating awareness, we've gone ahead to do capacity building. And capacity building, we've developed a training curriculum where the content of that training is being developed at the moment. Because if you create awareness and you do not have experts that will be able to guide that, it will create confusion where you have so many people interpreting the law in a million ways. Then the other has been compliance and enforcement. This is very key, whereby those that do not comply with the law, they're actually brought to book. So that is the direction that we are taking in the next 5 years, of which we are halfway done with that particular strategic plan. But beyond just looking at creating awareness, developing tools that can actually support, let's look at the scorecard of the legal sector. Because when you're advising entities on how to comply as lawyers, it's very important that you yourself, you understand the law and you can actually advise them from a very informed perspective. So currently in the register, it's a public register, we have more than 5,300 entities that are registered with us. The law requires that if you are a data controller, processor, or collector for that matter, you're required to register with the office. It doesn't matter if you're private sector, government, academia, or civil society, you're all required to register. So if you are collecting this data, of which law firms do collect that data, as Mr. Basoga said, whether you're receiving client instructions, you have a matter that you're litigating, or even just providing legal advisory, you collect and use such data. So law firms, within the definition of the law, are data controllers, because technically a data controller is the person who determines which information to collect and what to use it for. The law requires you to register. And that register can actually be accessed freely online at our portal, pdpo.go.ug, and search for the register. It doesn't stop at people who have premises in Uganda or headquarters. It also covers those that are outside of the country. As long as you're using and processing personal data of Ugandan residents and citizens, specifically for the citizens, the law requires you to register. So this applies to, I'll give an example of some of the products which are used by most Ugandans, social media services. So the big tech are also required to register within Uganda. But also it's not just about registration, even the enforcement of the law applies to them. So someone may wonder, if I have a complaint against any of the big techs or the social media companies, or it could even be a small company that is providing you with services and it's utilizing your data, and they do not have a representative in Uganda, how will PDPO enforce the law? That has already been covered because PDPO has joined international networks, starting with the one of Africa called the Network of African Data Protection Authorities. This is a network of more than 25 data protection authorities within the African region that have laws and authorities in place that implement data protection and privacy. And I'll use an example of some of the common complaints that we've been receiving, many to do with digital money lenders. We collaborate with other governments such as Kenya, where we can reach out and ask for certain information or to even assist us with enforcement of those laws. So those mechanisms are very important in making sure that even those that are beyond the borders of Uganda are brought to book. The question may be, how about those that are not on the African continent, that are on other continents? That has already been addressed as well, where PDPO last year was granted admission to the Global Privacy Assembly. Now this is at the international level, where over 130 data protection authorities join, and they even have a working group for enforcement. We have a number of matters against big tech companies, and we are using that particular technical working group to be able to bring them to book. We get the complaint and it's forwarded to their primary regulators that have primary oversight over them, and they get responses from them which are given to us. But going back to the scorecard for the sector, particularly the legal sector, is that, as mentioned, we have over 5,300 entities that are registered with PDPO that collect and process personal data of Ugandans. But I'm sad to say, and I use the word sad, because only 40 law firms are registered. And this is compared against the 1,271 law firms as of last year in September, based on the list that was published by the Uganda Law Council. So that's about 3% of law firms that are registered with the regulator. This registration is renewed annually, which means that there should be a person appointed as a data protection officer to monitor compliance. So even if we have 40 of them that are registered, only 24 of the 40 have actually renewed their registration. So which means that of the majority, they take up that obligation of registration, but they do not monitor other obligations of the law. So at 24, it gives us just about 1.9% of the compliant ones. But it doesn't stop at registration. The law requires that when you're registered annually, that is between July to September of every year, you submit an annual compliance report. So this is like an audit telling the regulator, over the year, these are the compliance mechanisms you put in place, you've mapped out the data, you've developed policies, and then you've conducted training on those policies and on the law to monitor internal compliance with the law. And still the numbers are very low. There are only, in the last period of reporting, only 6 law firms submitted annual compliance reports, which is less than 1%. So this goes to show that over 98% of law firms are invisible to the regulator, because when you register, the regulator has better visibility to support you as well. And it even makes it very troubling that those who are supposed to guide the clients on how to comply with the law, they are not even complying with the law. And yet there are penalties, as my colleagues will tell you. And I'll highlight, one of them. One, as Mr. Basoga said, your gross annual turnover, you can be fined a financial penalty whereby you pay 2% of your gross annual turnover. But it doesn't stop at just that. You can be imprisoned between 3 months to 10 years where you're found non-compliant. The regulator can also write to you to rectify any matter, and if you fail to take that up, then you will also be filed for every day that you're in default of that. Just about 2 to 2.5 weeks ago, there is a digital money lending company that has been arraigned in court. They were using personal data to process loans, and they actually were misusing it to threaten individuals on repayment. So this particular individual was actually remanded for 2 weeks, and the case is still being had in court. But one of the areas was not just misuse of the data, but it was also failure to register. So you can imagine if the regulator comes in and decides to enforce these particular provisions against law firms, and your clients find out that you is supposed to advise them on the law, you're now being arraigned before courts of law for failure to register. So I've talked about the so many entities that are registered with PDPO, over 5,000 of them. So what are we seeing from them? Because of the few lawyers engaged in this particular sector, many of them reach out to us. There is a great demand for regulatory advice. And over the about 3.5 years, we are coming to 4 years that the office has been in operation, we've received over 200 requests for interpretation of the law for regulatory advice. And we track a lot of data. Being the regulator, we also understand the value of data. So we categorize those who reach out to us requesting for this regulatory advice. We have a category of individuals called professional advisors that reach out to us requesting for regulatory advisory. Those constitute law firms, audit firms, accounting firms, and within that particular category of professional advisors, they form only 24% of the 200 requests that we receive for regulatory advisory. But when you break it down further to law firms form only just about 2% of the people that reach out to request for the regulatory advisory. But many of them are government agencies, private sector, we even have individuals, academia. So these, and they're mainly from entities that are registered with us. So we encourage law firms that if you advise these entities to actually get registered, and many of them have actually been supported by law firms, make sure that you check in on them. Many of them ask the question, what happens after registration? We realize that many of the law firms and even other professional advisors that advise these companies, they do not follow up with them or check on them on what other advice that they may need. As the regulator, of course, we are mandated by the law, provide the regulatory advisory, but we encourage you as law firms to tap into that particular demand. So one of the areas where many of the entities request for regulatory advisory has to do with how can I responsibly deploy AI in my systems. Systems for those that are developing systems, whether websites or portals, or even those that are finding ways of embedding AI in their operations. So as you know, AI, that is artificial intelligence, almost everyone uses it, especially with ChatGPT. So I'll start with the basics, and you'll pardon me if I use very basic terms. So AI, or artificial intelligence, it's basically having a system mimicking human intelligence. I'll give an example. Imagine if you get someone who is in primary one, I'll use an example of traditional education, and you have someone who is studying science, English, and all these other preliminary subjects. Then you bring that, I'll use an example of a girl, you take that probably 3-year or 4-year girl to a law firm to advise a client on a particular transaction and whether it's compliant with the law and what needs to be looked at in terms of due diligence. I'm sure many of us wouldn't do that, or actually all of us. And why? It's because she does not have enough experience or knowledge to give that advisory. So AI is in the same way. AI mimics human intelligence. It's just someone building a system, and it can only be helpful to you if it's actually fed with data. If it's just like that girl in P1, whereby she has to go through taking exams, reading, understanding, asking questions. So AI is given information on various subjects. So what most people use is ChatGPT. ChatGPT has been trained on lots of data sets from the internet, research papers, social media, to be able to understand lots of information. So when it gets enough intelligence, then it can be able to make its own decision based on the questions that you ask it. But we've noted that with artificial intelligence, for it to be able to understand and reach that advanced level of giving you responses, it's fed with personal data. And we've been receiving so many requests for regulatory advice around how do I use AI. I have a company, we have the HR system, we advertise the position, we receive 200 applicants, but we have limited time to come up with a short list. Can I use AI to come up with that short list? Someone has a contract. There are those contracts, especially by development partners, that can even be up to 500 pages long. You have a contract talking about the obligations, then talking about what is expected, maintenance if systems are being developed, and someone needs to be sure that they are well covered. So they give this information it's uploaded with AI to be able to analyze and give an analysis or even advisory. So those are the questions that we've been receiving. And I encourage us lawyers that, data protection and AI, since AI, the bedrock of it is really data, is that please pick interest in it. Many of the people that you support in registration come to us and they wonder, saying, well, I tried reaching out to a law firm, but what I got was not satisfactory. How can the regulator be able to assist me? The other area beyond AI, and I'll briefly talk about the products of AI, speaking to you as lawyers, and speaking about these products does not mean that I'm actually recommending them for use. It's just for explanation purposes. So I'll give an example again of ChatGPT. ChatGPT has a number of models. So there is the 4 series model, and then there is also the 3 model as well, then also the other. So if a lawyer is able to understand how to responsibly use these particular models, you can actually, your work can be made a lot easier. Where you'd have read a document or made an analysis that will take you probably half a week or 4 days, but when you know how to use these particular models, you can actually get a response in seconds. Especially with ChatGPT, it has what is called deep research. Deep research, look at it as having a PhD student in your office. Now, with the deep research, you give it a question, let's say, help me understand the data governance framework within Uganda, how it relates to the regional level, international level, but also what incidents of privacy has Uganda had. So for it takes a bit longer. It can even research up to 40 minutes, but it will give you research output of up to a PhD level student, or even a person who is a PhD holder. So there are a lot of benefits, especially around increasing your productivity when you use these particular models, because as a lawyer, there is another one by Google called Notebook LM. Now for it, when it's given documents, they can even be in PDF, no matter how big they are, it can give you a very good summary, but it can also help you read out those particular summaries and can help you map them out on what you plan to do. There is another called Cloud AI. Now this one is by a company called Anthropic. For it, it's very good it's the more refined one. Now, what makes it different from the others is that it's an AI model that is actually checks itself. Look at yourself that you've given an assignment to a junior associate. It's reviewed by a senior associate and a partner. Now, Cloud AI has those capabilities. It can even tell you that, the questions that you've given me, I don't think that, this is how you should be looking at it. Look at other sources as well. Then we have others, Perplexity. Perplexity, for it, it's more like a search engine, and it's actually very good with resources. Now, most of these AI models, they have the deep research, which means that they can do very good research for you and you check. Now, Perplexity gives you that particular research within a short period of time, but with more sources. But I caution you, and this is where we come in as the regulator, that there is something called hallucination in AI, which means that AI, because it's trained on data, can cook up facts, which are not even facts, can cook up instances that do not exist. So that means that the output that you're given, always check it against primary sources. It can come up with cases that were never decided. So it's being fine-tuned, just like that girl in P1, it also needs to be further trained. So as lawyers, beyond data protection and privacy, is that make sure that you can equip yourself, because so many people are asking about it, and so many people are using it. Make sure you equip your knowledge, scale up as well, but also we are encouraging entities that, so many people look down on AI. They say, and I see it on social media, they're castigating people who use AI. This one came up with an article written by AI. When you read on the history of AI, it reminds me of people who are being castigated for using calculators. People insisting that, us, you can be able to come up with computations without using a calculator. So as lawyers, when you come up with policies on responsible use of AI, checking yourself, they will make you way more productive. Because if there is a sector that actually needs to responsibly use AI and benefit from it, is the lawyers. Because remember, we are about data, we are about reading, we are about analyzing, and AI does that perfectly. And ChatGPT, they've been very intentional that they are looking at their latest models supporting lawyers in that regard. So in the Data Protection and Privacy Act, in the requests that we've been receiving, has an element of, if you use AI to make decisions that affect individuals, let them know that this was done using AI. If you need to be able to get a human to talk to, then that right is provided to them, especially around credit scoring, coming up with interest for loans, or even insurance premiums. So that's an area I thought I would talk to you about emerging technologies, about what we are seeing as the regulator. So I've talked about the challenges that these individuals and entities that are registered, they face. So what have we done as PDPO? As PDPO, we've developed tools to support those that are registered. One, we have a tool called the Compliance Toolkit, because when an entity is registered, it's supposed to map out its data that it's collecting. You can't protect what you don't know, so the mapping will help you know what you have, both in the physical form and electronic form. And you come up with controls on how to protect such data. That is having policies, training individuals on those policies, and other related areas around consent templates and all that. So that, we've also developed a training curriculum whereby we'll be training individuals on how they can actually equip the skills and build the capacity of others that are in that particular space. And a lot more, as my colleagues will talk about, how compliance, even beyond what PDPO has done, can actually be supported. So what are the global trends around what we've been talking about? Compliance by law firms, but also those that you support, AI and other emerging technologies. As lawyers, I'll start with Uganda to give you a better context. We did a survey, excuse me, of those charged with ensuring compliance with the law. We did it in 2022 amongst the registered entity. And this is what we established. Up to 32.5% of those charged with compliance were individuals with an IT or computer science background. And 27.8% of those were those with a business-related course, whether business administration, Bachelor of Commerce, economics, and the like, that are supporting these entities in complying with the Data Protection and Privacy Act. And lawyers were one of the least at 17.5%. This goes to show you that we have a law, and as PDPO, we are advising where people reach out trying to understand what does this provision have to say? How do I go about it? But the lawyers are not in this conversation. Other sectors, other professionals, like I've indicated, are the ones who are actually giving this advice. So lawyers are missing out on this because I don't know whether it's by design that they've decided to shun, and other professionals are actually taking it up. We've actually noticed something interesting. In one of the entities that were registered, the person that was designated as a data protection officer, it was actually a driver. Not that we think of a driver as being incapable, but when you compare with the rigorous nature of data protection and the training that a driver has, it is very limited. Why is this happening? Because the lawyers are not stepping up and taking up this particular space. Elsewhere, in Kenya, their figures are very different. The majority, the biggest majority of people who are actually advising these entities, as established by, they have a Data Protection Association, majority of them are lawyers. And globally, there is actually a 30% demand for lawyers, especially around data protection and privacy. And this was established by the International Association of Privacy Professionals. They run annual surveys. So you see Uganda is disconnected from the rest of the world, especially Ugandan lawyers. Elsewhere, the lawyers are very involved, they are advising, they are scaling up, but in Uganda, it is very minimal and almost dropping, because the more numbers of entities that we register, the less the lawyers we see that are actually involved in this particular space. Today, we'll also be talking about cybersecurity. A colleague of mine will go into what cybersecurity is for law firms. Very many law firms are going online, so there's a lot of exchange of information. And whether you're using personal emails to get this information, people are using their personal laptops, they don't have a bring your own device policy on how that should be handled. Law firms are actually suffering breaches and they don't know how to get around it, because remember, you have competitors in your space, people who are targeting you. If they're able to get your client list, then that means they can bring your business down. So lawyers should be thinking about this. If you have teams that do business development, if someone is able to get hold of that information, if you do not, then they'll be able to nudge you out of your particular segment or sector. So having information assets, coming up with controls, what we call the CIA, making sure that you keep the confidentiality of that information to only authorized individuals, the integrity is maintained, that information can't be changed in ways you don't expect to, and then you back up the information. I always ask a number of lawyers, especially who reach out to us, can you send us this document? We really need it. Many of them will say, I left it at office. I may get back to office probably the following day, or I'm on leave, or someone can't send it. And that is because that document is only kept on a device. If you lose that device, if someone breaks into your cabinet, it will be lost. The last A of the CIA of confidentiality integrity is the availability, that backup the information should be available whenever you need it. You can subscribe to some of these services of the Drive, and again, our non-marketing products, such as Google Drive, OneDrive, and all the others, even others offered by Proton, where we have smartphones, you can be able to access those documents, and even encrypt, whereby even if a person takes your devices, they cannot get hold of them. That conversation, my colleague will look at it in more detail. So I'll end with what my colleagues will be delving into much more detail, the opportunities that are available in this particular sector. we have clients, sorry, not we, but as lawyers that run law firms, you have clients. You know us even in the Personal Data Protection Office, you reach out to us, we call you our client, so you'll pardon my language. Because we look at you in a way of setting up particular protocols, how we should deal with you. So as law firms, you have a roster of clients, whether you advise them on land transactions, incorporation of companies, legal advisories. But do you ask yourself that, have you reached out to those clients, even if it's a small law firm with 5 clients, that you have advised them on how to register? Sorry about that. So the first opportunity is that reach out to those that you're already advising, telling them that there is this legal obligation and the regulator is enforcing it. Make sure that you actually register and you renew the registration. For those that are already registered, make sure that you advise them on renewing that registration, but also filing annual compliance reports. Where they experience breaches, make sure that you train them on what they should do to manage the breaches, but also they should be reported. We developed a training curriculum. We encourage lawyers when we roll it out that you can be one of those that sign up to be the training of trainers to deliver that training to your clients. We shall also be having a privacy audit manual whereby we'll be accrediting individuals on how they can audit data protection and privacy. That is something that you can look at as well. We'll be coming up with an alternative dispute resolution mechanism, and you as lawyers, you're well placed to tap into this as well. The others, I'll not go too much into them, but then there are also those of cross-border, where within the East African community, we are doing a lot of work, and if we can be able to export this expertise to other regions and countries, then the opportunities will be immense. My colleague will talk about them more in detail, but with that, I thank you for logging on. Hopefully we can change today, starting as law firms complying with the law, supporting our clients as well, but then also as individuals, because remember, your data subjects, if someone misuses your data, make sure that you raise a complaint with PDPO. There are so many of you out there, if you never report, the regulator will never know. Thank you for listening to me, and I wish you great deliberations. Good morning once again.
Thank you. Thank you very much, Mr. Birekuja. I have been taking close note of your comments. I must say that that was a very excellent submission. I think permit me, although we're in a professional setting, to use the word first-class submission, because I think there are several action points for us as legal practitioners who represent clients. I enjoyed the part of the presentation where you began with a legal framework, setting out how, this comes from the Universal Declaration on Human Rights and how it made its way into the Constitution, to the more recent Data Protection and Privacy Act. And I think one of our online members posted a comment in reaction to what you had said. She mentioned that lawyers are also carelessly inserting and uploading client data onto AI tools, and that obviously presents significant risks. And I think, that's something. One of the key points that I felt you made was also understanding the strategic plan of the regulator and then planning along those lines. But what I found to be dire is that, only 40 law firms are registered, and yet by the nature of the business of a law firm, client personal data is often being received. That is actually a part of several reporting frameworks, including anti-money laundering and several others. So I think that's obviously an area of improvement, including submitting the compliance reports. As always, when the regulator speaks, one of the primal concern of clients and counsel has always been what are the fines, and so it was very helpful that you highlighted the 2% gross fine that can be levied for failure to comply with the law. But I also felt like understanding that recently officials from a money lending company have been they are facing legal proceedings in court, and I think that's sometimes the best way to understand the law, by the consequences of the law. And I think this takes us back to our jurisprudence classes where they told us you understand the law from the judge who makes the order or the consequences that follow from non-compliance. And I think not just here, we've seen in other countries, we've seen major corporations like British Airways being fined close to £20 million by the Information Commissioner, who serves in the same capacity as the Personal Data Protection Office. And so that's critical. And obviously, as a technology and privacy lawyer, I was very pleased by the remarks you made, for instance, on paying close attention to artificial intelligence and data and the overlap, and especially the obligation to inform any data subject that if any decision is being made in relation to their rights, that is automated or based on AI. But I also know that different organizations, including credit reference bureaus, banks, microfinance institutions, are figuring out ways to work with data to improve client experience. It's really, really important that you make sure that a consent framework has been, observed. Our clients actually consenting to you training the data to maybe better serve or provide a better service. I think all those are important. And I think one of the key points that the director mentioned was also that regular trainings are important. And I think as lawyers, it's important to attend, for instance, such an event, but also to regularly update oneself on what is going on. So thank you very much, Baker, for the keynote remarks. We are extremely pleased with your presentation and have taken note. We'll move on to our second speaker, Mr. Opio Isaac, who will address us on data protection compliance for law firms. And I think this builds on to the points that Mr. Berikuja, the acting National Director of the Personal Data Protection Office, has mentioned, that only 40 law firms are registered and only a portion of them are complying. And so we hope that Mr. Opio Isaac can address us specifically on understanding and fulfilling legal obligations for client personal data. Mr. Opio's profile, he is a legal associate at Kismo Advocates and a team lead at the Techno Legal Advisory Center, Uganda. Mr. Opio is a technology lawyer, writer, and researcher. He is the co-founder of the Techno Legal Advisory Center, Uganda, an organization that was established to address the challenges that arise between the law and technology in society. He has researched and written extensively about the intersection of law and technology for both online and print publications. Opio has assisted tech startups and organizations with data protection compliance through staff trainings and legal advice. He is a frequent speaker and writer on legal technology trends and innovations. He also serves as a member of both the Data Protection and Privacy and Technology and Telecommunications Committees of the East African Law Society. In terms of his professional qualifications, Mr. Opio received a Bachelor of Laws from Makerere University and a postgraduate diploma in legal practice from the Law Development Center. He is an advocate of the High Court, a member of the Uganda Law Society and the East African Law Society. Mr. Opio, I am very curious to hear and understand the obligations of law firms as far as it concerns handling customers' data, but more specifically, to understand how lawyers can be critical in this space. Mr. Opio, you are most welcome.
Yes. Thank you very much, Joel, for that introduction. Thank you very much, Joel, for that introduction. And I'll delve right into the discussion, which is themed as understanding and fulfilling legal obligations for client personal data protection. You know, most times when we are training organizations, when we're training most organizations, for example, if you're training a hospital staff or a fintech, you tend to, the task is not very big. You're basically doing a two-in-one training. You're training a data subject, the individual, and then you are training them as the staff of the organization, as data processors or collectors and controllers. But for lawyers, it's kind of a tricky task because they're going to be training 3-in-1. We have the data subject because every lawyer at some point in their life is a data subject. In their day-to-day work, they are data controllers, collectors, or processors. So they have those obligations also under the Act. And then thirdly, they are legal advisors. They are basically supposed to be the advisors for their clients and should be knowledgeable about data protection because at any point they will be tasked with advising clients. So they are basically training people who are going to be training other people. So it's a very big task, and okay, I will go right away into the discussion because we don't have a lot of time. Data protection is a very wide area. You can actually spend the whole day and even come back tomorrow to discuss, but we have only a few minutes to confine everything and we conclude. So I'll go right into what is data protection compliance. Our duties as lawyers every day is compliance. All the clients that we work with, our duty is to make sure we comply with the law. The only difference today is that we are looking at data protection compliance, which basically refers to the identification of laws, regulations, standards, or best practices that apply to an organization's activities in relation to personal data, and on the other side, meeting the requirements for the collection, processing, safe storage, and disposal of personal data. Yes. So this ensures that personal data is safe throughout its life cycle. And by life cycle, I mean personal data goes through stages from the moment it's collected to how it is handled, to how it is transferred, to everything that happens in between the collection till the moment the personal data is gotten rid of, for example, by destruction, erasure, or anything after the retention period has ended. So data protection compliance ensures that personal data is safe throughout its life cycle. And for Uganda, as you all know, our law is the Data Protection and Privacy Act. It's the primary law regulating the use and collection of personal data relating to Ugandans within and outside Uganda. So we realize that every Ugandan and every entity that has personal data relating to Ugandan, who is either within Uganda or outside, the law applies to them. And so the law firms also fall under this umbrella, since they are collectors of personal data. So the law applies to all institutions, as I've said, and establishes strict guidelines for managing both personal and sensitive personal data. Yes, so it further creates tools for ensuring that there's constant oversight. It allows data protection data subjects to exercise their rights and also informs them about their rights, ensures the secure handling of personal data, issues to do with incident response in case there is any breach of personal data. So data protection compliance has various benefits for law firms, which is beyond, as we have seen people discussing earlier, it's beyond just avoiding fines and fulfilling what the law says. It's very beneficial because, first of all, your reputation as a law firm is very important. You need to have trust of your clients as well as third parties. There's nothing more assuring than a client knowing that their personal data is safe with the law firm. They'll definitely trust you with more work. Even third-party service providers. That's why you see most entities like banks and insurance companies require their third-party service providers like law firms to register with the personal data protection office, because that is how far they can go to know that you have in place safe systems that ensure the safety of personal data. And unfortunately, as we have seen, that most people actually just comply with personal data as just the process of ticking the box. Your third-party service provider, you are required to register. You go and register, bring the certificate, get the work done. You don't follow up beyond registration. So we need to move from that, we need to move from that to proper compliance beyond registration. So, understanding data protection is therefore very important for lawyers to implement best practices, as we shall see in our discussion. So I found it important that we have to have we need to have an understanding of some definitions in the Data Protection Act. For example, we have a data collector. A data collector is the person that collects personal data. That is the law firm, in this case, that collects personal data from the client or from its staff. Any point of collection, the law firm becomes a data collector. A data controller is, on the other side, is someone that determines the purpose for collection of personal data. So if the law firm is collecting personal data, for example, at the point of hiring a staff member, when it collects that personal data, it becomes the data controller. If it collects personal data from a client, for example, to draft a contract or to institute a suit, it becomes the data controller because it is determining the purpose for which the personal data is collected and how it is processed. And then there we have a data processor. This is an entity that processes data on behalf of a data controller. Now, for a data processor, in terms of a law firm, I'm going to look at a situation where, for example, you receive instructions from a client to institute a suit. So you're going to be receiving details of, for example, the defendant, and you are supposed to use that information to institute the suit. So you collect it from the person giving you instructions. For example, I'll use the example of a bank. If a bank gives you instructions to sue a loan defaulter, at that point you become the data processor because you are acting under the instructions of the data controller, which is the bank. And then there is the data protection officer. That is the person that is appointed by the law firm to ensure compliance with the act, with the Data Protection Act. And it is only my wish that one day we will all be data protection officers for different organizations, whether internally or externally. Yes. Also, then we have a data subject. That is the person from whom personal data is collected. Just like all of us are in this meeting, the Law Society collected our personal data for purposes of this meeting. So we are all data subjects at the moment. And then the other one is personal information. That is information from which a person can be identified. That is telephone number, date of birth, and so on. Yeah, and then the other document is the privacy policy. That is basically a statement of commitment by an entity that shows its commitment and on protecting personal data, also shows the data that they collect and process and so on. And yes, so lastly, we are going to look at the word processing, which we are going to hear very many times in our discussion. Processing is basically any act that is done to personal data beyond collection. So if you look at things like filing, organizing, sharing, and so on, all that is processing personal data. So there are types of personal data that a law firm will definitely come across in their day-to-day operations. We have personal data. I would prefer to call it personal identifiable information, which is similar to the other definition that I stated. That is just basic information that can identify an individual. And then on the other side, we have sensitive data. This is information that is sensitive and reveals very sensitive aspects of an individual's life. And if you look at information like someone's sexual life, information to do with someone's sexual life, information on financial status of someone, health status, and so on. That is information that you will raise your, will you be concerned if someone asks for information compared to things like your national identification number or telephone number. When someone asks for your sexual life, details about your sexual life, you'll definitely be scared. And for that, the law provides for special protection to that category of data. And if you look at Section 9 of the Act, you will see that it is provided for special consideration. And then, also we have data subjects. These are the individuals that I said from whom personal data is collected. And in the day-to-day in the day-to-day operations of the law firm, definitely we have a lot of personal data. And I would divide this into two. That is information that is derived internally, that is held internally, and then the other one is the one that comes from external sources. The first one is clients. Of course, clients, we get the information for transactions and so on. Staff are also data subjects, and they are entitled to the same rights and protection under the Act. Internship students, contractors, even visitors, because some law firms have the registration process for visitors to their buildings and so on. So they are all data subjects. And then the other one, we have external data subjects that come from outside that make the law firm become a data processor. Those are, for example, as I said earlier, defendants and other instructions that a law firm will receive. Now, the important thing to note here is that the law firm has a legal obligation under the Act to protect the privacy of all data subjects, whether they arise from within the firm or externally. So you, as an associate or a partner in that firm, you have the same level of protection, just like the client has under the Act, or other external persons that have, the persons that come from outside the firm. Because there's a tendency to focus mainly on clients and leave out the internal, the internal members of our firms. We tend to focus only on clients, but even the employees and anyone that interacts with the firm beyond client-advocate relationship is a data subject. So what are the obligations of law firms? The obligation is one, that is provided for under Section 10 of the Act, is to protect the privacy of all data subjects by collecting, holding, or processing personal data in a manner that does not infringe on the privacy of the data subject. So there are quite a number of actions that a law firm must take to ensure, to protect the privacy of individuals and ensure that data is collected in a manner that does not infringe on the privacy of data subjects. We have one registration with the office that has been talked about so many times in the last 1 hour. Having in place consent requirements, adhering to the principles of personal data protection, having in place security systems. We shall have a look at all these as the discussion goes further. And then let's now go into the real gist of the discussion, which is compliance. Now, for compliance, just to make matters easy, I decided to break them into two. We have the low-hanging, I call them the low-hanging fruits, and then the best practices. So I'll start with the low-hanging fruits. The low-hanging fruits of compliance are those that require minimum effort and resources. It will be so disappointing if you are a law firm and you don't do any of these things, because if you compare the cost of these low-hanging compliance practices together with the cost of not having them in place, you realize that the cost of not having them in place is actually far much bigger than having them in place. So, low-hanging fruits, these are the most easily achieved set of compliance measures or practices requiring minimum resources to implement by the firm. One of these is registration with the office. Registration with the office is compulsory, and every law firm must register with the Data Protection Office, at least at the moment, because there's no they have not been exempted from registration. And upon registration, you are given a certificate, and you also put on the National Data Protection Register, which is accessible to the public. Now, it will be so disappointing for your client to go and search. Some clients are genuinely concerned about their privacy. So if a client goes and searches on the register and doesn't find your law firm, you're most likely going to lose the client, actually. You're going to lose a client who will take the work to another law firm that has registered. Also, when you search on this register, you'll see the status of the registration, because some law firms' certificates can just expire and they don't renew. So that status is also provided, whether it's still valid or it has expired. And registration is only 100,000 Uganda shillings. So honestly, this is quite affordable for a law firm. And as we have discussed, as Becca has discussed, he has told us only 40 law firms out of 1,200 have registered. So that shows that we are doing badly, because registration is bare minimum compliance. Is the bare minimum compliance requirement that we must all at least have, and we can start from there. Another one is appointing a data protection officer. So a data protection officer is basically the person that ensures that the law firm complies with the Act. And also is also a point of contact for the firm together with the outside world. For example, data subjects, even the personal data protection office, in case they have any issues or inquiries to make, they'll contact that person. So a DPO can be any person because the law does not provide for a legal, does not provide the legal qualifications for who a data protection officer should be. So anyone can be a lawyer in the firm, an administrator, HR. You have interestingly heard Becca talking about an entity that appointed a driver as their data protection officer. So it's a blanket, you have the blanket discretion to determine who can be your data protection officer, but at least have one in place for easy contact in case of any matters to do with data protection. And the other one is the data protection policy. Well, every law firm, I assume, must have a data protection policy because it shows that the firm complies with the minimum requirements in the Act. For example, it shows the purpose of the information that is collected, how it is collected, and why it is collected. For example, it also talks about the retention period of personal data. It provides for the contact details of the personal data protection office in case of any inquiries or requests by data subjects. And that policy must be put to the notice of a data subject at any point. If someone is coming for an interview, let them know about your data protection policy, because at that point you're collecting personal data about them as you hire them. The employees within the firm have to know, the clients have to know. So it's a public document that shows your commitment to safely handle personal information. Then the other one that is also low-hanging, that's the low-hanging compliance practices. Regular training of staff. Because staff I'll call them the engine of the firm. They handle the day-to-day operations of the firm, and they have files that they interact with, they have clients that they interact with. So they have to have knowledge of security of personal data. They have to have knowledge of the data protection law, how to handle the law and update and keep them up to date with any policies that the firm has in terms of personal data protection. So regular trainings training doesn't mean you should have one only. There should be regular, consistent data protection training for all staff and at all levels, starting from the top to the bottom. Everyone that works in the firm must have knowledge about data protection, from the partners to the associates, to the administrators and managers, to the ladies and gentlemen that do the cleaning, to the security guards, because you never know. This lady that cleans might come across some sensitive information, but how do they handle it? Where do they take it after that? We have seen situations where people's personal data has been, especially the hard paper filing kind of thing. You find people's personal data is being shared online, is being used to wrap roadside food like Rolexes and so on, and it's very sensitive to have everyone, therefore, trained on how to handle personal data in the organization, that is in the firm, and it must be regular. At least for you who is attending right now, you're lucky that you have had this training, but there should be one internally within your firm also to give other people the chance to know about data protection and its practices in order to ensure compliance in the firm. So those are the four low-lying or low-hanging fruits for data protection compliance. And deep down inside your heart, you have to ask yourself, how is your firm faring in terms of these low-hanging fruits? Is it good or bad? You answer, but I think I would say it's not good, because if you have only 40 firms that have registered, then we are generally doing badly, and we have to do something about it. So the other one is, I'll call them the best practices, because they require kind of professional backing. So these are professional procedures that are accepted as being the most effective to ensure data protection compliance by entities. And then they are also provided for under the law. So we have one, the issue of, I've divided them into 7 best practices. So we have one, knowing what personal data that you hold and the principles of personal data protection that apply to the farmer. And then 2, having in place a complaint handling procedure or systems. And then 3, mapping data flows within the farm. The other one is having in place a data retention, deletion, or destruction policy. The other one is having in place a data subject access request system or procedures. And then we have security systems as well as data breach response procedures. That one will be, these last 2 will be deeply looked at by Mr. Mugabe. We will be handling the cybersecurity aspects of data protection. So, now what do we mean by knowing the personal data you have and knowing the data protection principles that apply to it? The law firm has an obligation to know what constitutes personal data, first of all. And then 2, you must have you must know the lawfulness of possessing that personal data under the Data Protection Act. 3, you must know the personal data that you hold within the farm, and that calls for the creation of an inventory of the personal data that you hold in order to monitor the personal data that the farm has and also ensure continuous monitoring and updating of that inventory. And then further, understand the principles of personal data protection that apply to the personal data that you have collected. These data protection principles are basically the rules that regulate the collection and processing of personal data. And these are provided for under Section 3 of our Act. And there are 7 of them. I've listed them down. Briefly, they are accountability. You have to be accountable at all times for the personal data that you collect as a farm. It must be collected lawfully with a legal basis for its collection, as provided for under the law. Personal data must be adequate and relevant at all times. 3, personal data must be retained only for a specific period of time or when it's still necessary for processing, for the original purpose of processing. And then 2, you must ensure the quality of the personal data throughout its life cycle. And then transparency and participation of data subjects. That's where issues to do with data subject access requests come in, allowing data subjects to know what personal data you hold about them and so on. And another one is security, which is very important and ensures that personal data is safe throughout its life cycle. So the principles must be adhered to throughout the life cycle of personal data, and data subjects have the right to complain to the Data Protection Office in case they have any grievance about how you have handled their personal data, or in case you are in breach of any of the principles that I've stated above. So it's very important to know the personal data you have and also have an inventory of the data that you collect as a law firm. And then the next one is mapping data flows. Mapping data flows. Mapping data flows allows the law firm to monitor personal data. You know, when a client walks into the firm and a file is opened, at that point they'll definitely give you personal data. They'll give you personal data that you will use in that transaction or in that lawsuit, and you open a file. So that file has to be tracked from the moment it is created, from the moment it's opened, to who gets hold of it, where it is stored, when it is taken out of the filing, the place for filing, and finally until the moment when the personal data or the personal data is gotten rid of through destruction and so on, or until the transaction has come to an end. So there has to be mapping of that file, and that is very practical, and I'm sure very many of us do it, but maybe you have been unconsciously doing it because unconsciously doing it already, but it's very important to map data, personal data flows within the law firm. And then the other one is data retention and or deletion. You must have in place a policy that governs, the issue to do with retention and deletion of files. Because personal data is not to be held indefinitely. The law requires that after some time, it must be deleted, or if the transaction or the processing period, the original processing purpose comes to an end, you need to destroy or delete that personal data. And there are many ways of doing that. For example, you can erase, delete, destroy, and there are other mechanisms such as anonymization and pseudonymization that you can apply when carrying out the data deletion or destruction. So having in place a data protection policy for retaining files for regulatory and operational compliance and inform data subjects about the policy. So as I said earlier, you need to have a data protection policy in place, and that policy will definitely inform the data subjects that we have a data protection retention policy in place, and you can access your information in such and such a manner, requesting for us to delete the personal data or to destroy it when our relationship comes to an end, and so on. So data subjects must be informed about that policy, and you must ensure that periodically the data is reviewed to ensure its quality and also remove useless data. And lastly, when keeping, as law firms we have, which is very okay, I think we have the tendency of having the practice of precedents. When an intern comes and they need to draft a plaint or they need to draft an application or a contract, there's a tendency of saying, look, we have done that before, and you refer them to a file. So they'll use that file to pick out that document and use that as a precedent to draft the contract or the instructions that you have given them. So here, when keeping precedents such as contracts, agreements, judgments, legal opinions, pleadings, and so on, ensure that you delete personal data from it when the retention period comes to an end. Yes, so that is noted. And then the other one is the data subject access requests. This basically, first of all, is a right under the Data Protection Act. Data subjects have the right to make a request to the firm. One, requesting that, to confirm that you have personal data about them. Two, to provide a description of the data you hold about the data subject. And then three, they will also maybe need to be informed about any third parties that hold their personal data. So you must have in place the data subject access request procedure to handle requests from data subjects and inform the data subjects about their rights and whom to contact in case they require to access their data. And yes, the law provides for time periods within which to reply and also acknowledge receipt of these data subject access requests. For example, you have 30 days within which to reply and handle the whole process, but you have 7 days within which you must acknowledge receipt of that request. And it is very important that you must explicitly provide for the data subject access request, because you don't know what point someone might exercise this right. So you must provide a specific, for example, a specific email that handles that procedure. You don't want someone to send you a request and then it goes up into your spam and not be able to identify the request, and then to bring issues to do with compliance and filing complaints with the Data Protection Office, which is a process that is not good, and it's not good to go through it. So you must have in place a data subject access request procedure to handle data subject access requests. And then the other issue is having in place data security systems. Data security systems must be in place to ensure that personal data is safe, it is secure, its integrity is maintained, and the confidentiality of information is also maintained. And the law provides for for what we call technical and administrative measures that an organization has to put in place to ensure compliance with the Act. We have one. I'll look at the technical first. These basically refer to systems and other technical components of the firm and apply to issues to do with the hardware systems of maybe the computers and so on, the networks and devices. So we have issues to do with cybersecurity and the antivirus protection system that the law firm has, issues to do with firewalls and malware scans. We have encryption. We have physical security systems like CCTV and biometrics access procedures to certain rooms and offices. And then we have passwords, setting strong passwords and ensuring that documents that have sensitive information are password protected. We have, finally, the appropriate disposal methods. At the end of it all, when you don't need personal data, how do you dispose it? You must have in place the appropriate methods of ensuring that personal data is disposed in the right methods without the possibility of re-identifying the data subject. And that's where I say the training comes in, because you never know who will land on a piece of paper that has important information in the firm and how do they handle it. So you need to have in place that disposal procedure. And the other one is the administrative, basically, organizational measures. That is, for example, having in place business continuity plans. Business continuity plans basically put in place measures to ensure that there's a backup of files and personal information in case of any disaster that happens. And then we have also information security systems. Yes, you need to have those in place, which is also a requirement when you're registering with the Personal Data Protection Office. They will require you to submit your information security policy. So law firms must have that in place. And then awareness and training, I can't emphasize that more. It's very important. And other policies that we shall see later on. And then the other one is data breach response procedures. Data breaches are bound to happen at any time, and how prepared is the organization to respond to this breach? So you must have in place that procedure. And my colleague Stephen will look at that in depth later on. And then we have an issue to do with data protection impact assessments. A data protection impact assessment is basically an assessment of an activity, of an activity in relation to the risks that it poses to personal data. So in case a law firm intends to have in place new products or install new systems in place, and that information, and they need to use the personal information of clients or staff, they need to carry out a data protection impact assessment to determine the level of risks and also how to address those risks in place. We have a 9-step procedure for carrying out a data protection impact assessment. I think I'll share it because of time, I'll share it together with this. A link to the data protection impact assessment guide to help organizations carry out data protection impact assessments, and that will guide you on how to do your data protection impact assessment. And then the other issue is, of course, there are benefits, and everyone has talked about them. The benefits of data protection compliance, the benefits of data protection compliance. There are very many, and these are the most important, I think. It enhances your reputation and trust among your clients and third-party service providers. When you have in place good data protection compliance measures, you are most likely going to mitigate the risks of data breaches. It also improves the accuracy of your data, because you'll only collect information that is necessary, accurate, and therefore you will not go through that rigorous process of having a lot of unnecessary information. And then lastly, you have the issue of competitive advantage, which is similar to reputation and trust, because a client will trust you more when they are sure that personal data is safe with you compared to someone who is not compliant. And then the other one is fines and penalties. Yes. And then lastly, we have also challenges that, of course, we as lawyers face in terms of data protection compliance. One of them is resource restraints. I mean, in the firm, for example, if you require to appoint a data protection officer, everyone else is already occupied. So you'll be left with the dilemma of hiring a new person or giving that task, shifting that burden to another person who is already occupied with other roles. So we have that resource restraint that plays a big challenge. And then the other one is third-party risks. In our day-to-day operations, we operate with, for example, other registries and courts. ICMIS, for example, and the URSB portal, you don't know how safe their system is, but you only pray that they are safe because you don't know the risks that their system poses when you submit the client's information on that. And then lack of awareness, yes, which can be solved by training that I talked about earlier. And then technological changes. The big issue now is artificial intelligence. Everyone is adopting artificial intelligence in their transaction, drafting documents. Some clients, some lawyers can copy and paste the whole document or take a photo of a pleading or any document and put on these AI platforms. What are the risks that are posed with these systems and how prepared are we? So that's another challenge that we have as lawyers. And then the volume of data, of course. Right now, as I speak, I'm sure there's someone seated next to very many files, and all that has to be given the same level of protection under the Data Protection Act because each file is a new client. Each file is a new client. So the volume of the data that we hold and handle every day is a very big challenge for us in our day-to-day operations. And especially when you now add it to another level, which is data protection compliance, will really be a challenge. And then lastly, we have divergence of legal compliance. You know, most law firms have clients from all over the world. So you have to know which law applies to your client, because if you saw from our law basically applies to, the Data Protection Act of Uganda applies to all citizens of Uganda who are living within and outside Uganda. So any law firm, maybe any entity that is collecting or processing personal data of a Ugandan, whether in the UK or in the US, is bound to comply with our act. So the same applies to most data subjects who come from other jurisdictions. So there is need for lawyers to keep abreast with the legal requirements in other jurisdictions. For example, the GDPR, those ones are very strict about the protection of data, of the data protection rights of EU citizens. You have to know the rules that apply to them. If a client is coming from, for example, the US, you have to know which rules apply to them. So there is that challenge that we are basically facing, which requires us to keep abreast with almost all legal compliances from different jurisdictions. And then, yes, lastly, the solutions are basically the best practices that I looked at earlier. Those are the low-hanging fruits and then the best practices. And those are them, and they're here, you can now, they are self-explanatory because I've explained them earlier, and you can adopt them in organizations later on to ensure proper compliance with the Act. So that brings me to the end of our discussion on understanding and fulfilling legal obligations for client personal data protection for law firms. And if you realize the topic basically was looking at client personal data protection, but as law firms, we collect personal data from various angles, including staff and internally, like the staff and the employees and so on. So I try to expound and not only look at personal data of clients only. So thank you for that, and yes, I look forward to any reactions and questions that may arise from there. Thank you.
Thank you very much, Mr. Opio. That was an excellent presentation. And if you have any questions or concerns, or you'd like some further clarity from Mr. Opio, please post your questions in the Q&A part of your Zoom application. He should be able to address them there in writing, but also we're going to have a panel discussion In that discussion, questions will be addressed. Thank you very much, Mr. Pio, for your presentation. Again, that was a first-class presentation, and I take note of your submissions. I think some of the key points that you mentioned, was compliance having various benefits for law firms, specifically building trust and confidence. Imagine a client has come, they are going through divorce proceedings, they have disclosed information to you, and then that information is openly accessible on an online blog. That can be a very great cause of anxiety and mistrust. But also you mentioned that the law firm is both a collector and controller, and you specified, for instance, the kind of information they may receive from staff, from visitors at the law firm, from clients, but also through the online platforms by which someone signs to access a building or the books they sign in to enter. All of that, as you emphasize, creates a legal obligation on the firm to protect the data. Your presentation also curated the different types of data, emphasizing sensitive data, for instance, data that relates to religious beliefs, sexual life, and financial status. It would be crazy that, some people ask for this information without following, because I think there's a higher threshold of requirements when you're asking for such information. And I think some of the key action points was the regular training of staff. And I think one of the most fundamental is having a privacy policy as a firm and security measures. And I think you also reiterated some of the points that a member of the audience had posted in the chat room about being careful as you engage with clients' data with external artificial intelligence or AI systems. I know that a number of law firms, I know that maybe 1 or 2 law firms in Uganda have designed internal AI frameworks that allow them to use that internally. I think that may be more tenable, obviously subject to the law, than having to upload information for a client across different platforms. So thank you very much, Mr. Pio. Your presentation was not only comprehensive, but it addressed the specific prompts that you were required to speak about. Thank you very much. So to our online audience, if you have any questions, please let us know by using the Q&A chat room, but also you could post in the chat room. We'll be happy to hear your views. And we're going to have a panel discussion after the next 2 speakers. And if your questions are raised, the earlier that they are raised, the easier it will be for the panelists to address them in the panel discussion. So I encourage you to share that information. We're now excited to welcome our next speaker, Ms. Barbara Among Arinda, the Executive Director of the Credit Reference Bureaus Association of Uganda. She will address us on client support and business opportunities for lawyers. Her brief bio is as follows. Barbara is a seasoned executive with over 14 years experience in managing complex corporate, regulatory, data protection, legal, and compliance issues. Currently, Barbara serves as the Executive Director of the Credit Reference Bureaus Association of Uganda, an umbrella body for licensed credit reference bureaus in Uganda that works closely with financial institutions. She is also the founder of WinServe Consult Limited, a consultancy focused on data protection. Barbara is the pioneer lawyer in the CRB industry and one of the pioneers establishing judge assistants in Uganda. She is a strong advocate for corporate governance and serves on the members and business development committees of the Institute of Corporate Governance of Uganda. She has held key roles with global brands such as Experian and Credit Info, where she worked as in-house counsel and the data protection officer, or as we like to say, the DPO. She actively collaborates with regulators, including the Bank of Uganda, the Personal Data Protection Office of Uganda, to promote corporate governance, compliance, and information security networks. Through WinServe, Barbara seeks to deepen her expertise in data protection and privacy by partnering with local and international law firms to develop and implement best practices. In terms of her professional experience and qualifications, Barbara holds a Bachelor of Laws from Makerere University, a postgraduate diploma in legal practice from the Law Development Center. She's also a certified information privacy professional, CIPP, and holds a certificate in credit and lending practices from the Uganda Institute of Banking and Financial Services. Outside of her professional roles, she is passionate about art. This is quite a robust CV. The most outstanding part of this CV is your passion about art. I myself must confess that I was an artist. In my high school, I was often referred to as a doctor of art because I used to draw portraits of people. So I am happy to hear that more than data protection and privacy, we have in common a passion for the arts. I would like to welcome you, Ms. Barbara. May you please take us away. Thank you.
Thank you, Joel. I hope I'm very audible. It's a pleasure and an honor to be hosted at the Uganda Law Society building. We were hoping that this day will come. And I'm happy to be one of the people that have been able to be part of this engagement this morning. So thank you, Uganda Law Society. Thank you, all the Uganda Law Society members. My presentation, typically, when we met as a team of panelists and we were discussing the different topics that we would be able to engage in, for me it was very important, and for everyone else, to be able to do presentations or engage the members on areas of practice where we are involved on a day-to-day, so that we are able to give value to you, but then also for us to leave when we've learned and to be able to identify different areas we can continue to support each other as professionals, and also to give back to the community that we work with. So I'll just go ahead and share my presentation. So I guess you guys can see my presentation. So like I've said, my presentation is really going to focus around most of the things that I've been able to experience, that I relate to, and I hope that when we are discussing, and I'm using the words very carefully, I'm choosing the words discussing because this is not a one-decided engagement. We anticipate that whereas we may be here physically and the different members are attending online, you should be able to interact with us. We would love to hear from you. So please, as I go through the different points, feel free to put down any comments, seek clarification, ask the questions, and you can also share your experience in the chat section. My presentation will cover trying to understand in the context of lawyers what client support is, and also looking at data protection, the subject that we are discussing today, and then understanding the role or justification for legal support in data protection matters, the opportunities and areas for client support, all the services that can actually be offered by lawyers, and then being able to understand the trends and the typical industries where you can look as lawyers to drive your proposals or initiatives around data protection, as we shall see. And then what are some of those emerging topics, or what are the hot topics around data protection? For instance, as a lawyer, if you're seeking to get expertise in this area of data protection, what are some of the areas you could actually focus on? Or if you intend to engage parties in particular discussions, it could be a training or whatever it is, what are some of the areas that could interest you? Then how can you position yourselves as a law firm? It's one thing to identify the opportunities, but then how can you be able to seize the opportunities? How can you position yourself in the market to take that? And the other, of course, is the skilling and getting up to speed with the required expertise, and then I'll conclude. So in the context of a legal business, we would say that client support basically refers to the range of services and assistance that lawyers within your law firm you would provide to your clients to ensure that their legal needs are met efficiently, effectively, and with a high level of professionalism. This client support, as seen, it plays a critical role in building trust, maintaining relationships, and ensuring satisfaction. So legal support for law firms and for lawyers, it's just not about you as a law firm sitting back and waiting for a client to bring a file to you or a need. It's also you being able to identify areas in which you can support a customer or that person that you would, a prospective customer. They may not necessarily be your customer, but you probably see there is a need for you to serve. And then over and above identifying the needs to serve, the whole approach, is it customer-centric? Is it enriching? Is it a great experience that your customer is going to get? This is what client support is all about in the context of a law firm. So what is the role of lawyers and what justifies legal support to clients in terms of data protection? Becca earlier on and the other speakers have spoken about how lawyers are positioned in such a way that it's very easy for you to actually take advantage of data protection space in terms of exploiting the different opportunities. One, we get to recognize that lawyers, you are the center of putting together legislation when it comes to data protection. You're the people who put together these laws. You review the laws, you pursue reforms, you drive advocacy and representation. So it goes without saying that the role of a lawyer is very central to data protection implementation, compliance, monitoring, and enforcement. And of course, driving reforms, like I said. And then the role that you get to play as lawyers is complementary to the role of the regulators. So as lawyers, when you have data protection office, when you have key regulators, let's say like Bank of Uganda, who have industry laws that speak to elements of data protection, lawyers come in very handy to be able to play a complementary role. Again, speaking to the first point, for instance, if it comes to interpretation of the laws, you are the first go-to people to be able to interpret these laws. If it comes to particular drives on reforms, you're the first people to play this role. Many times regulators are sticking to particular areas, and so often they're very conservative, they're very risk-averse, and it's important that the lawyers, with the different skills and the different the academic background that they have, they then come in very handy to be able to play that complementary role to regulators. And also, you narrow the gap between regulators and your clients. So you will have the regulators on one hand, and then you have the private sector, your clients, who are on the other hand. How do you narrow this gap? But then also, you could have lawyers that are standing or representing regulators. You have a key role there to play in terms of narrowing the gap or being able to support the regulators and the particular parties that are regulated or that are supervised by the particular regulators. Then also you play a very big role in terms of ensuring legal risk mitigation. You do legal risk mitigations. Ultimately, you're able to save your clients a lot of money by being able to monitor, identify, and be able to come up with mitigations for different risks within the different spaces that you are. And then also, given the rise in technology, electronic processing of data, cross-border data transfers, and data-driven businesses, lawyers would be the best person to be positioned to understand different areas when it comes to the different risks that are associated with these different developments. And then, of course, with the need for, with the coming or the increase of data protection regulations, there is a need for compliance, and you have a role to play there. We've talked about mitigating risks, and then, of course, you play a huge role in ensuring that you're able to support your clients to promote operational efficiencies. So where a customer would spend a lot of time being able to understand or analyze situations or investing money in areas where they're not able to get value, lawyers, then you play a very significant role in supporting clients, which then helps clients to make better decisions, have quick turnaround times in terms of their decision making, and this, of course, has a return on investment when it comes to doing business for them. So if we are to look at the current snapshot of the markets, the industry, because I'm sure many of you are thinking, we are speaking this data protection thing, but as people in Buganda will say, "Mfunira muwa, ntandikira wa." Yeah, help me. I've just borrowed those statements from Buganda, because usually people want to find out what's the catch. What's the catch for me in this new area of practice? So I'm just going to look at so far the net of people that have registered, the entities that have been registered with the Data Protection Office in Uganda. So we have a total of 5,380, that's an approximate number. So 5,380 institutions that have registered with Data Protection Office as data processors, data collectors, data controllers. So this net, or this pool of people, typically would form the basket from which this can actually be your customers. This can be your customers. But this percentage is not, is Becca there? Becca is there. When we look at this number of people that have registered all entities, we see that there is still much to be desired in terms of other entities that need to come and register. What we are saying is that 5,380 is just another fraction. It's not the complete picture. We still have thousands of people that need to register with the Data Protection Office, who would then potentially be your customers. So imagine how many law firms do we have, and also speaking that not all law firms would specialize in data protection, and you're looking at this pool, and we are even saying much more. Of these numbers that we have, we do recognize that some of these people that have registered with the Data Protection Office, they are actually already your clients. So you have some of these people as your clients, but the question is, are you evolving as a law firm to be able to meet your customer needs and demands, and be able to give the client support that we talked about, the all-round, the holistic picture, going over and above the traditional aspects of a law firm, Are you able to offer that support? So some of you already have some of these customers, but you're not offering the 360-degree services that they need. And then many of them actually don't have lawyers. They don't have support. Many of them, the year comes to an end, they need to file annual compliance reports. There is no one to support. Then there are so many that have not been registered, and they just don't know where to start from. So that's when you come in. So we also see that around the world, we see about 71% of countries that have enacted data privacy laws. Like the way Joel said, this is not something that is going away. This is something that is here to stay. If for anything, the laws are just going to get fine-tuned with the times, because the times have actually informed putting in place data protection laws. We've seen the evolution. We've seen that, bulk electronic processing of data. We've seen that there is a lot of digitalization. There is a lot of e-commerce. So without a doubt, the shift in the economies and the way we are doing business informs that we need to have data protection laws. And as we have more advancements or technological advancements, these laws are just going to get fine-tuned. We'll have specific ones that speak to specific industries. And also, this is not something that is Ugandan only. It's something that is global, and it started from out there, and we have also adopted it. Also, we note that enforcements, that's something that we need to be mindful of, and something that could also be used as a pitch as we are engaging our customers, is that the cost of compliance is quite, if your customer is not going to comply, or yourselves, to data protection laws, then the cost, the fine that comes with that is very, very high. So it's important that people like yourselves step up, you seize the opportunities to be able to support your customers. And when I say opportunity, it's not only about the money, but then also for your clients to see you as someone who is, to see you and recognize that you're a service provider that is all round and is able to give the support that they need. So that is very important. Then what are the opportunities and areas? I think I missed something. Just a minute. Just give me a second. Okay. So what are some of those opportunities or areas where you can exploit when it comes to data protection? Or what are some of those things that you can actually do? There is a range of services, but we'll start with the obvious one that we always do as lawyers: legal interpretations and advisory. This is something we do every day. And I've found this many times when you're working in an organization, like the organizations I've worked for. As lawyers, because you've gone to school, you know how to interpret the laws, you can be able to read and understand. Many times as lawyers, we think that these things are obvious. We think everyone should be able to understand. It's not the case. You'll be in a company, or you'll be in-house, or you'll be an external law firm, and someone will bring to you something, or sometimes they don't even have to bring it to you. And the value that you bring as a lawyer when it comes to legal interpretations and as advisory is very immense. So that is one area that you can exploit. The other area is that being able to understand laws and interpret them, you're able to train and create awareness. But then also being able to train and create awareness, it means that you need to be a person who understands the business of the client that you're serving. So for instance, I've worked with the credit reference bureaus, I've worked with financial institutions, fintechs, and within that space, for myself to be able to position myself within my consultants, which is WinCap, or work with other stakeholders like the way I'm here giving this training, I should be able to understand how financial institutions operate. What sort of data do they collect? I should be able to understand the nitty-gritty and the processes, so I come from an informed place to be able to do the training and awareness with my knowledge, of course, of my legal knowledge and the skill of legal interpretation and advisory. The other, we've seen that we still have so many Ugandan businesses and different people processing personal data that actually need to do registrations. Have you guys been able to look into this? Have you tried to engage Data Protection Office to collaborate on some of these things so that you can support different businesses and entities to actually do registrations with the Data Protection Office as required under the data protection laws? The other is, yes, now maybe you've done the registration, you've done the awareness, but are your clients, for instance, they've done the registrations, or they've not even done registrations, but some of them are relying on particular informal policies or frameworks around data protection. Are you able to do audits and assessments around their processes and business operations to be able to identify the gaps when it comes to data protection? That's another thing that you can do. The other, of course, after understanding all these things, how they are operating, lawyers can play a huge role in terms of putting together data protection implementation frameworks. So you put together a whole plan of how these people will make sure that they are able to comply to the laws and enforce a culture that moves with data protection and privacy. The other is managing incidents and data breaches. Could be simple things like putting together a communication. I'm actually not going to say simple things, because another thing I've been able to see within the corporate space is that people always think that writing communications is very easy, or managing particular incidents is very easy. And that's where a lawyer comes in very handy. Another role that we play as lawyers is like, it's almost like your communications people or your PR to some extent, because you're able to see the risks and you're able to cap those in the communications, whereas you're trying to cement relationships and of course protect reputation. So that's another thing that you can do. And then of course the other is contracts and other document reviews. So for instance, you could have a client who is a financial institution that is acquiring people's personal data at the point of opening up an account. Does that account opening form have contract terms or consent clauses that are sufficient enough to take care of the purposes and other details relating to the information the bank is collecting? So it's important that you offer this support. Review the contracts that they have, review the consent documents that they have, review the notices that they have on data protection. Do they need to draft other documents? Draft the documents and customize them to their businesses. And that's where the whole point of being knowledgeable about your customer's business comes in handy. The other is being able to review and draft policies and procedures and the required notices. We also have a growing need of cross-border data transfers, managing cross-border data transfers. How do you advise the customers? Are you able to look at the laws in another country and advise accordingly? Are you able to look at the proposed data protection, data transfer agreements that have been put in place? What's the criteria in that country? How do people handle data? What are their systems like? The other is data impact assessments. So you have a client, they want to bring a new product on the market. Are you able to identify the risks when it comes to data protection? And are you able to propose mitigations? How are you supporting your clients when it comes to data impact assessments or rolling out of products or new processes that they're bringing in place or new ideas that they're bringing in place? That's where you come in handy. What are you doing? Then, of course, we've spoken about the requirement for filing compliance reports. For many people, this is an area they would rather leave to someone like a lawyer or a data protection office. The other is litigation and dispute resolution representation. I think that should be obvious. And then we have the role of a data protection officer. So a data protection officer, contrary to what many people think that these need to be in-house, they don't necessarily have to be in-house. This can be an outsourced service within a law firm that understands the business of a customer. And of course, after going through the other steps, where now you're offering service and support to a customer. And then, of course, generally regulatory compliance. There would be ad hoc things that could come from the regulator over and above the law that we have, the Data Protection Act and the regulations. So for instance, you would have a directive from a data protection office. Are you helping your clients to ensure that they are complying with the different requirements? I saw some time back, Data Protection Office had issued something to do with schools and other stakeholders not publishing children's names and other details following the final exams of school. These are things that we need to look out for. Are you able to monitor changes within the market that trigger certain requirements that then will help you support your clients better? Then we are seeing that data protection is just not in Uganda. We see other countries that have just actually passed laws, and there are other countries that need to pass the laws. You as a lawyer in Uganda, you can still position yourselves as a regional or a global practitioner who does offer data protection services locally, regionally, and globally. Okay, and then how are you able to identify the client? So we've seen the services that you can offer, but then how can you identify the potential customer that you can work with? Because yes, you could be there in the law firm and you don't know where to start from. The first place I would say is, first of all, you need to understand what data protection is all about. We've tried to say a lot of things here, but over and above this, you need to have more time to appreciate and absorb what data protection is, because we didn't study this in school. But like I've said, it's straightforward, given that your lawyers read the act, do a bit of research and understand. So first of all, you need to do client mapping and profiling. So you have existing customers. So first of all, understand your customer set that you have internally. Are there parties that would potentially pass as, customers, prospective clients that you can offer data protection services? Then look around. Look around. Many of you are writing proposals, you're engaging different businesses, you're giving in services that you can offer, but you're missing this segment. Why? Because you're not understanding your customer. You're not profiling your customer. So you need to profile your customer, understand your customer, and be able to write a rich proposal or engage them on best ways that you can support them. This can be new services that you're bringing on, or they can be add-ons. And then the other, of course, is client engagements and survey. Have conversations with your customers, all new people that you're meeting. Understand them, understand their need. You can as well do also industry surveys. These help a lot in different businesses, where you get to understand your client needs as they keep evolving. Then you also need to monitor regulatory changes, because you could have a customer today that is not being, that doesn't fall under data protection, but with their business changes or regulatory changes, this customer then falls in this bracket. I think I've catered for the two topics together. A customer whose business changes, business profile changes, and where there are regulatory changes that could affect your customer. Then, what are some of those emerging trends and topics? Becca talked a lot about AI, so I'll not really get into AI. So we have a lot of AI talk going on. Then there is the need for data governance. So data governance basically is how institutions or different parties that are dealing with personal data, how are they able to handle or manage data that they hold? What are the processes? What are the procedures? This is very important, especially when it comes to entities that transact or deal with a lot of third parties, or actually they are subjected to particular checks, vettings, due diligence processes. It puts your client in a better spotlight when they're handling their data well in terms of aspects of how they handle their data. Then there is also a lot of cross-border data transfers. We have multinational organizations. We have different regional organizations that come to Uganda. And then you'll find that a certain global brand has regional offices. However, everything is centralized in another country. For instance, it could be a human resource database where it's information to do with employees and everything, personal data to do with them, and it's not in Uganda, it's kept in another country. And then, of course, there are other things beyond this where it could be, I'll give an example of, let's say, credit reference bureaus. I could be in Uganda, but then someone wants to do a check on my credit report in the UK. My credit report has so much personal data. It has my financial records. It has my information that identifies me. How do we handle this? How can a firm in the UK reasonably and legally be able to access information about Ugandans and vice versa? If we need to do checks on a UK citizen from a UK organization, how can we do this reasonably and legally? Then the other has been the argument of costs of doing business versus regulatory requirements. So people always think that sometimes regulations strive for development or being able to become innovative. So this is another huge debate on how to strike a balance. I think the argument has always been how we can strike a balance, because either being free to do certain businesses or come up with innovations has its advantages, but it needs to be subjected to particular legal requirements to make sure that there are particular protections, especially to individuals. Then we also see the evolving role of data protection officers. This is something that is important. So whereas you have something that is legislated within the law and something that we've known traditionally, the role of a DPO has gone beyond just what we see, specifications that have been given, let's say within the law or other things that we do practice. They need to be more akin to the bigger picture of the business. They need to work hand in hand with the strategy of the organization. They need to be engaging with boards that drive the strategy of the organizations. And they need to have different tech stock of different areas within the business. And then, of course, there's been the argument around employee privacy and monitoring, biometric and facial recognition laws, cybersecurity, big threat around cybersecurity, but our colleague will later on get to speak to that. Then if you're going to look around, where should you start? What are some of those industries that you can look at that are processing a lot of personal data? So Uganda, interestingly, and Joel, you'll let us know after I'm done, the fintechs in Uganda are big. Like, we have a lot of fintechs in Uganda. And most of these, their innovations are driven on personal data. So it's important that you pay attention to this, get to understand how many fintechs do we have in Uganda. You can engage FITSPA. FITSPA is an association of fintechs in Uganda. You can look up FITSPA, be able to engage FITSPA, and you understand. Then we have telecoms. That's another area, a lot of personal data that is processed. I'm sure for telecoms, those ones are quite obvious, but it's about understanding what they do. Then we have healthcare, As for healthcare, you guys, you know, you will go, you will fill in a medical form, you put in everything, an insurance form, you put in a lot of details, they're doing 1,000 tests, all these records are kept. And then we have social media and cloud solutions providers, we have e-commerce and retail. So you will see on e-commerce, these days everything is happening online, but for things to be concluded, we enter a lot of our personal details. And then also under the education system, the same thing, we share a lot of our personal information. Just continue. As law firms, how can you position yourselves? How can you position yourselves to say that now I've been able to see what we've seen, I've seen how I can identify the customer, I've profiled my customer, I've seen the emerging trends and topics, I've seen the opportunities that I discussed earlier, the area, industries of interest where you can look. Then how can you position yourselves? First of all, it starts with your strategy. As a law firm, what is your strategy? You need to understand what's your vision. Today you've been doing just litigation. You just don't wake up one day and say, tomorrow I'm jumping into data protection. No. You need to do some research, market research, be able to understand where you need to get. What's the vision of your law firm? Where have you been? Where are you? Where do you need to get? You need to be realistic. And I think why I'm saying realistic, it's because many law firms are sort of stuck in a certain level of practice. Legal practice has evolved. The role of a lawyer today has evolved. So you need to be you need to do a good examination of your law firm. And you will not be able to achieve this by just looking within your circles. Look around, have conversations with people, understand what are other people doing out of Uganda, benchmark, and then come up with a firm strategy with objectives and initiatives that you think, if you think that your objectives or where you are is something that can incorporate data protection. Also looking at the customers that you serve. Like I said, do your research, understand, profile your customers. Understand your niche, then you can do your firm strategy and understand. If you're going to adopt data protection practice, then it means that you need to build the skills and expertise. It's just not about being able to read the law and understand. It could be obvious, but there are things that go beyond that. And then as you do that, you need to build partnerships and collaborations. Work closely with PDPO, understand what you need to do. And then forge partnerships. You can forge partnerships with industry associations. Could be FITSPA that I'm talking about. Could be Uganda Bankers Association. Understand their customer better. And also this leads you to the networking to be able to get in a bracket or a pool of customers that you can work on. Yeah? And then, of course, when I'm talking about networking, it's just not about the typical events that we go for, like now we are having our CLE training. There are so many engagements that happen on the market where you can engage and see areas of learning and seize also opportunities. And then also invest in legal technology and also come up with risk and compliance solutions. And then also make sure you have good enough awareness and educative materials. So I've seen many law firms starting to do this. You'll publish free material on your website where you're telling people about different trends, topics, and giving advice. And that is amazing. So even with data protection, you can do the same thing. Have information that informs customers about data protection at no cost, but you can be able to get a benefit in other ways. And then come up with different client acquisition and retention strategies, focusing on the value add that we talked about, client support. Then you need to go digital. I think I talked about investing in legal tech, and then build customer-centric products. Have a customer-centric approach, and then look into the new areas of practice like cross-border practice. So how can you skill up? How can you get more skills around data protection as a law firm? The starting point can be engaging with a PDP, or they've done a couple of trainings, and most of these are recorded. They are recorded, they are available on YouTube. Please go and inform yourself. Watch these videos as you go through the law. Be able to understand. If you need to engage them further as a law firm, you can engage them. Also, you can look at other local people that do a lot of trainings or engagements on these, like myself, and you'll be able to skill up. The other is to look at the data compliance manual that was developed by PDPO and familiarize yourself with that. When you do that, because it's giving a step-by-step guide, the good thing about lawyers is that you love to read. Your clients don't love to read. This manual could as well be used by your potential clients to do a bit of implementation and all these things, but you take advantage of the gaps within the market, get the data compliance manual, familiarize yourself with it because it becomes like your Bible in supporting a customer. You can get international certifications like IAPP, like the way myself, Becca, and I think other people in the room also have, and then do look out for your staff. Look out for mentorship and peer learning programs. There are quite many, especially for girls. We should start some for boys. So there are lots for girls. But then also we can also look at industry peer learning. There are a lot of things that are happening. Yeah, so those are some of the things I can advise. And my conclusion as I come to an end is to say, as a lawyer, the need for a lawyer within this space is we cannot overemphasize it, honestly. Like you stand at the center of everything that happens around data protection. And also, as lawyers, you need to understand that the legal profession is evolving. And as it evolves, you need to grab onto the different areas of practice, like data protection, that you can take on and be a lawyer that can offer much more value than the things that you've been doing every day. As you do this, you cannot do it in isolation. You need to work with other law firms. Can be local firms, can be international law firms where you collaborate, where you partner. You can work with other organizations like consultancies. You can work with, what are they called? You can work with the regulators. And then, of course, you need to drive a business. The customer is looking for a business-minded legal profession. Many times, lawyers are very risk averse. Okay, I don't know that to call it risk averse. Many times you interpret the law, and many times it's this law says no, this law says that, this law says that, so you cannot do that. But the customer wants to hear solutions. The customer wants a business-minded legal profession that is going to help them get more business in, be able to get more revenue, and be able to be positioned in a market in such a way that they will be able to stand out. So are you that lawyer? Are you that lawyer? That's what you need to look at. And data protection positions you in such a way. So as I end, let's all understand that the future within this space belongs to lawyers, and lawyers who are just not lawyers, but lawyers who are also business thinkers, innovators, and trusted partners. The opportunities to seize are quite many, so let's go for them as lawyers. Thank you, everyone.
Thank you very much, Ms. Barbara Among Arinda. That was a very good presentation. Again, I think all the presentations we've had today are first-class material, and I think that you have even upped the standard. I am personally even more particularly excited about the next speaker. So thank you so much. I think that, you wrapped it up really, really well, especially on being business-minded, innovators, and trusted partners as lawyers. Not just interpreting the law. The law says this, and you stop there. And yet, the law, there are always ways in which the law can be interpreted and upheld in a consistent way that also achieves the client's interests. But also I felt your presentation was quite empirical. You took an empirical approach with statistics, just showing the opportunities that lawyers have in this situation, specifically compliance audits, giving trainings, contract and document review. I know some people have been wondering exactly, and you used the correct euphemism from Luganda, where you mentioned what's in it for me. And I think that if these services are offered, then lawyers will be paid because there is value that is added. I think, you prompted me on the fintech issue. Obviously, fintechs, and these could be payment system providers, mobile money operators, they obviously rely a lot on data, and people in fact might use, for instance, mobile banking services much more than a traditional banking service in terms of the daily money and volumes of money that move. So because of that, there's a lot of historical financial data that is used, and therefore I think that's a serious opportunity. So I also like the points you made on benchmarking from different jurisdictions. I think that should be the approach because in certain other jurisdictions, they've had more regulatory interventions, penalties, and there is obviously a lot to learn from that. So thank you very much, Barbara, for that excellent presentation. It was a very great pleasure to listen to you. Now, to our online audience, thank you for tuning in. We're continuing with the next session, which is going to focus on cybersecurity for law firms. And we are pleased that we'll be having an information technology professional who is also the manager of data protection at the Personal Data Protection Office in Uganda. He's going to address us specifically cybersecurity concerns. We've had a lot of incidents. I think even the PDPO has done some investigations where there were unlawful access to personally identifiable information, what we call PII, from some of the government corporations. So what should we really be thinking about as legal practitioners in terms of cybersecurity? But I also think that part of being a data protection lawyer means that you have to have an IT person that you consult, that you, for instance, if you have to do penetration tests to understand the level of risk and how you can protect the integrity of the system. So I think the next speaker is particularly well placed to address us on this matter. So I will go over his profile, and then I will invite Mr. Stephen Mugabe to speak to us. Mr. Mugabe is an information technology professional with over 14 years experience in IT across IT support, systems administration, asset management, IT consulting, system design and implementation, IS audits and assessments, and data protection and privacy compliance and regulation. Stephen currently serves as the Manager Data Protection Affairs at the Personal Data Protection Office of Uganda, which is Uganda's principal regulator for the Data Protection and Privacy Act. Before his current role, he worked as a systems analyst at the National Information Technology Authority, where he played a key role in audit and assessment of a number of government systems and was involved in the analysis, requirements gathering, and design of key government e-services. Stephen has undertaken a number of IT consulting engagements within the banking, health, telecoms, NGOs, and within the government in Uganda and outside, including assignments in Malawi, Sierra Leone, and Lesotho. Stephen has worked with AH Consulting, Muju Care Limited, and also worked on the USAID Sustain project. In terms of his professional qualifications, Mr. Stephen Mugabe is a graduate with a Bachelor of Science in Computer Science. He is a certified information systems auditor, a certified information security manager. He's ITIL certified for Security Plus and SEL certified data analyst. Clearly, we have the right person in the room, and I think it would be helpful to know we have a lot of knee-jerk reactions in cybersecurity. Something has happened, there's an incident, someone's phone has been hacked, and then all of a sudden emails are being sent, data has been accessed, and now all of a sudden everyone in the firm becomes an expert. What do we do? Let us call an IT, I know an IT guy somewhere. So it's a lot of reactionary approach, and I believe that you are going to at least illuminate us a little bit more on how law firms should really think about cybersecurity. So join with me in welcoming Mr. Stephen Mugabe, who who will address us for the next 30 minutes or so on cybersecurity for law firms. Stephen, you are most welcome.
Good morning, and a pleasure to be part of this engagement. I'm not sure if Joel hasn't said so much of my personal information, but that will be a discussion for later. I'll talk about cybersecurity for law firms, and specifically through this engagement, I want us to understand what cybersecurity is, what we need to know in terms of the cybersecurity risks that we face as lawyers and law firms, what we should do to prepare, to manage, and also what happens after an incident happens, and also an understanding of why we actually need to be keen on cybersecurity as lawyers. To start this off, it's important that I don't take it for granted that everyone understands what cybersecurity is. It is simply a practice of protecting systems, networks, and programs from digital attacks. Now, the digital attacks are what we call cyber attacks. And quite often when we say protecting systems, everyone quickly thinks of the complicated systems with firewalls, enterprise resource planners, but systems could be simply the way you do your work, the way you manage your processes. So a system is as simple as how you do your work, how your operations are. Even if you do not have the complicated computerized systems, you still have a system by the fact that you carry out some work and you do it in a particular way or in following a set of procedures. Now, cyber attacks are usually aimed at accessing, changing, or destroying sensitive information, sometimes to extort money through ransom, or interrupting normal business. Now, these cyber attacks could be intentional, unintentional, depending on the assessment of the attack in question. And when it comes to cybersecurity, we use technologies, processes, policies, and practices to ensure that we protect the systems that we have, the devices that support the systems from any attacks. Now, when we are talking about cybersecurity, we are looking at the practice. How are we ensuring that our systems are secure from any attacks? And the primary objective as to why we have cybersecurity practices is to reduce cyber attacks and protect systems against unauthorized exploitation. Earlier on, Baker talked about a security triad, that is confidentiality, integrity, and availability. For all our operations, for all our systems, it is important that we ensure the information we have, the information that we deal with, is always kept as confidential as possible. The integrity should be top-notch, and availability. If you lose any of the three aspects, then there is no security in your place. We don't want you to have information so secure that it is not available even when you need to use it. You need to ensure that the information is available in the correct format and only accessible to users who are authorized to perform specific uses for that particular information. With the understanding of what cybersecurity is, it's also important that we get to know what are some of the common cybersecurity threats that we can face as lawyers or law firms in that regard. I'll start with the basic, that is social engineering. You know, when we talk about cybersecurity, people are worried about hacking, losing data, failing systems, and forget the primary and simple things that are very close to us. That is starting with social engineering. Now, social engineering is accomplished through malicious activities with human interaction. I'll come to you, you're my friend, and through our discussions, I pick key information. Through our discussions, you gain confidence and you're able to even give me your password. Before you know, I can transact on your behalf. Before you know, I have access to information within your law firm. I know who you're representing, what case, and the details of the case, just simply because I've interacted with you and you're making security mistakes of giving out sensitive information. It's a social gathering. After 5, we are talking, and before you know, you're revealing so much information that you need. So these human hacking scams tend to lure unsuspecting users into exposing data or even malware infections. I'll come to you and say, I need help, I need to print something, hand you over a USB disk into your computer. You're helping me to print because of the social circle that we belong in, without knowing that me giving you my USB drive could pass malware, it could pass viruses into your computer, or even pick information from your computer without your knowledge. So it is important that we start to look at cybersecurity from the basics. Let's not think of cybersecurity as something complicated. Let's look at it as something that we live with and begin our protection and our security from the closest person that we have. In complicated or in more security terms, we bring in an aspect of zero trust. You do not have to trust anyone, you don't have to trust any systems, you don't have to trust any operations, just for the sake of trusting. So once you get that in your mind, you're beginning to build a safe cyberspace, you're thinking security. Don't wait for things to happen so that you can know there's an issue. So social engineering is very big. It's a common problem simply because we do not regard it as a big issue. So what do we do in this case? Always avoid things that look so glittering. I'm going to send you an email, you're going to get an email winning a lottery in which you haven't participated. And somehow, because we like money, you're going to click. Before you know, your information is lost, or you're accessing malware that is even going to affect the entire corporate network. Avoid attachments on emails from senders you don't recognize, and be wary of emails or phone calls requesting for account information. Well, there are different ways you can share account information. Why do I, Stephen Mugabe, choose to call you at 9 p.m. to give me login credentials? So it's important that we always take keen note of the social environments that we live in and what could come with the particular requests that we get. Another common cyber threat that we have and need to take keen note of is phishing, which is a type of social engineering attack used to steal data, including login credentials and any other key information, especially if you're logged onto your computer. And we have a common practice of using a single password for all our logins. So the moment I know how you log into your computer, I can access your email, I can access your bank, because you don't want the burden of having to remember multiple passwords for different operations that you undertake. So with phishing, an attacker is going to come in as a trusted source and gets you into opening an email or an instant message or a text message, and you're tricked into providing key information, thinking you're giving the information to the right person. It's very important that we take note of the simple details. I know you're expecting an email from Stephen Mugabe. Take an extra minute to check. Well, the person sending is Stephen Mugabe, but what are the details in that particular email? If you pay close attention, you'll find the details are different from an email that you're expecting. And also, take keen interest in the contents of the information. This person communicates to you. How all of a sudden is this person now expecting to get 80 million Uganda shillings from you? This is a discussion you've never had. This is you who does not discuss particular things or do not expect this kind of information. But because you trust and don't pay keen attention to the details, you're subject to a phishing attack because you're thinking you're dealing with a trusted source. And then another common cyber threat is malware, which is malicious software that is intentionally designed to exploit devices, networks, and data. So data criminals use malware to steal sensitive information, disrupt your operations. When you're in the IT space, you get calls, you get requests, my computer can't do this, my computer is malfunctioning. Some people tell you you're sending multiple emails to them, yet in actual sense you haven't sent any email. So in the process where you're not able to send any email or do anything with your computer, malware is in the background sending out multiple emails to different people. So at the end of the day, you find that you're sending out information that you're not aware of, and within that could be very sensitive information, and you don't know what could come out of that. And then relatedly, we have another common cyber threat, that is ransomware, which prevents you from accessing your devices, accessing your data, and in exchange, you're asked to pay for some money to be able to retrieve or gain access to your computer. So with ransomware, it is a type of malware that prevents you from accessing information. It will access your computer, encrypt all the data that is on your computer, making everything on your computer unusable. And then in the end, you're going to have to pay big sums of money, because this information means a lot to you. It means business for you. It means a lot for your clients. And anyone having that information with you has the entire life. It has all your work life. And in most cases, you're left with no option but to pay. But if you go back to first principles, where does this come from? You could have trusted a source that was wrong. You could have used or connected to infected devices. And you know, these come in glittering ways. Because in most cases, we want the free things. You're out at a restaurant. You're quick to connect to a free Wi-Fi. You don't even know who is managing it, but because it says free Wi-Fi. And you need to be online. You don't know what you're downloading. You don't know how the connection is managed. So it is important that we take note of connections that we use, it's important that we take note of devices that we connect to our computers to ensure that we have a bit of security. We are talking the basic cyber security that we need to have, the best practices, simplicity at its best. Before you go into the sophisticated implementation of firewalls, it starts with you. Let's understand the basics and have good practice. Another common cyber threat that we need to take note of is business email compromise, where attackers impersonate legitimate business emails and trick employees into taking action. Now, in this case, someone usually impersonates as an executive or as a vendor or a trusted source to gain credibility. You're going to get an email instructing you to transact some money, and the email appears coming from your supervisor, coming from your boss, coming from the CEO. And one thing to note is everything that we put out, all the information that we put out, can be used by attackers in any particular way. It's not going to be by coincidence that when I'm on a trip to the UK is when you're also receiving an instruction to send money because I am somehow stranded at Heathrow Airport. Okay? So because I've put out a lot of my information regarding my travels, I'm putting out a lot of information regarding everything I'm doing, the hacker gets to know information about my movements and can use this particular information in any way. Now, in this case, they are going to send an email to my office indicating how I'm stranded and I need a quick transaction of, say, $500 to my account. And before you notice, $500 is sent to an account without even scrutinizing to check and confirm that the names are actually that. But because you're trusting a source, and this is coming to your business email and masked into a legitimate communication, you find yourself taking the action. So with the business email compromise, the challenge in this case is the use of certain levels of urgency for you to carry out an operation. It's very urgent, please do this. It's very urgent, please do this. And the attackers usually exploit the trust and use action emails. Please do this, complete this in the next 5 minutes as we have to make a transaction. Please send through this email immediately because we need to do ABCD. By the time you get to understand the details of the person who requested for the particular information, a lot of information has gone. You've sent an email that has a very sensitive client information, and you don't know where that is going to end. Another common threat that we look at is mobile device vulnerabilities. We all love the convenience. We all love our phones. We all love our tablets. We all want to respond to email wherever we are. But it also comes at a cost. Now, cybersecurity does not say we don't have to be mobile. We are not saying you don't have to be mobile. We are not saying you have to be at one desk. We are just calling in for that extra bit of care, that extra bit of awareness. Okay? If we are going to allow you in our IT operations to use your mobile phone to connect and transact on behalf of the company through email, then there should be some legitimate actions that we take. Your phone should have the latest firmware. your phone needs to have antivirus, and you need to be monitored over whatever you're doing. When we talk about monitoring, then a bit of legal eyebrows are raised. Our privacy, our rights, and everything. Now, it's going to be a trade-off. Do we, as a company, allow you to expose us because of your rights? Okay. So it's important that we create the awareness so that you know, as you're doing this, it is also a risk. We explain to you the risk it causes to the organization because it leads to unauthorized access to data. It is very easy for someone to snatch your phone. It's very easy for someone to snatch your laptop. And before that, all the information that you have worked on, all the confidential company information is gone. So we need to be very careful with the mobile devices that we use and ensure we put certain levels of protection. If we're going to allow you to move around with the laptops, then we need to ensure that the data is encrypted so that even when someone steals the laptop, they are not able to access the data. We can lose the laptop, but not exposing the company data. Another common cyber threat, and this is a very big one, the insider threat. Me and you, who are part of the organization, we are given all the access to the information to do our duties. But then, within our operations, we don't take the due care, we don't respect the rights that we are given, and end up causing data breaches. We end up causing not using our credentials legitimately. So it is important that we understand in everything that we are doing to secure information, it all starts with our staff. You can have the best security practices, you can have the best security implementations, you can have the best firewalls in terms of security, but it all starts with the information. You're authorized to do financial transactions on behalf of the organizations, but you also put that information to unauthorized users. So it is important that we know cybersecurity starts with us, and we have a very big threat, that is the insider threat, that actually even has access to information from a legitimate perspective. So it is important that as we grant the access, we also take a further step on limiting what kind of access the people have, put further restrictions on what one can be able to do. You may be allowed to use the information, you may not be allowed to copy the information or transmit the information to any other source outside the organization. Now, we know what cybersecurity is. We have a little bit of understanding of some of the common cybersecurity threats. We can't talk about all the cybersecurity threats, but why is cybersecurity critical for us in the law sector? One, I know law firms have and deal with a lot of sensitive data for the different clients. You'll find a law firm with 5 different practices. You have information on financial records, you have intellectual property information, you're handling data protection on behalf of your clients, and all this information is within your hands. So it is very important that for you, who is handling this information, treat it with utmost security, because a single breach of information could lead to exposure of corporate contracts, intellectual property, personal details, and before you know, my lawyer is facing my other lawyer for breach of privacy, for not handling my personal information well. So it is important for us because as lawyers, you handle a lot of confidential information. Now, that confidential information is handed to you in confidence. You need to keep it as secure as possible. And we'll look at the different ways we can be able to secure that information. So you need to have in place different measures that can be combined together to maintain confidentiality and also uphold ethical standards and protect the reputation of your firm as well. Why it is critical for law firms and lawyers in general to have good cybersecurity practices is compliance with regulations. As lawyers and law firms, we are subject to various legal and regulatory requirements, such as data protection, that require you to implement robust cybersecurity measures to protect the information that you have. The Data Protection and Privacy Act of Uganda puts it clear that a data controller, data processor, or any person who collects or processes or holds personal data shall observe security safeguards in respect to that data. So that creates a primary responsibility to you. When I entrust you with my intellectual property, when I entrust you with my contract information, when I entrust you with my personal data, for any reason, the data protection laws require that you put in place security safeguards to ensure that that information is secure. So it is in your interest as a firm, it is in your interest as a lawyer in your practice that you have in place robust measures to ensure good security of the information that you have. And this extends on to other legal regulations, and as well as the GDPR also calls for implementation of robust security measures that could be technical or organizational to ensure that the information you process is secure. The other reason as to why it is important is around reputation. I know most law firms work based on a foundation of good relationship with their clients. And if you're the kind of firm that loses client information, if you're the kind of firm who is always in and out of court for data breaches, you're going to lose credibility, you're going to lose customer trust, and in the end, that means you're losing finances as a firm. Even beyond that, you're going to face litigation yourself, because certain breaches will lead you to face the law, and in the end, you have to find yourself paying fines based on the particular direction that the law takes. Now, with that in mind, as to why you need to consider cybersecurity as a law firm, we need now to look at where the risks in cybersecurity are when it comes to your practices. Now, for every practice, for everything that we do in terms of cybersecurity, and why we need to have robust measures goes to the way we handle data and our data management practices. So in whatever we are doing, we need to ensure that we secure our data management practices. That is starting from the way we collect information, how we store information, how we process the information, how we use the information, and eventually how do we dispose the information. If I need to collect information from you, how am I collecting this information? Is it in a secure way? If I'm going to use paper-based collection methods, how secure are these methods that I'm using? If I'm going to use a system, how secure is the system? Who has access to the system? All these are things we need to think about. We need to think about security as we are designing our systems, as we are designing our processes, to make sure that the way you collect information is in a way that you do not expose any kind of information to unauthorized use. How you secure the information in storage. We have different storage mechanisms. If you're running the paper-based systems, you could be having cabinets. The cabinets are lockable. Everyone has a key. There are those cabinets that are left for certain people. That is still security in practice. Now, when you get to use of systems, who has access to the systems where you store the information? Are these systems readily available when you need them? And processing. How do you process the information you've collected? I'll give an example. I'm applying for a job at your farm. I've put in my application. Now we are 100 applicants. It's time for shortlisting before interviews. How do you go through that process of picking out the best 3 that you want to take on for interviews? Are you using the right people? Or the people that are doing the shortlisting are actually going to get the information to the candidates before it is official? And then how you use the information as well as the disposal of the information. It's important that once you have the information, if you're to get rid of it, ensure that you get rid of it in a way that is not going to put out that particular information to unauthorized access. And then we look at the practices that we need to have in place as law firms to ensure that we have good security of the information. I'll start with the basic, which is data discovery and inventory. It's important that you get to know what kind of information you have. If you don't understand how sensitive the information you have, then you can't design the right security measures. So it's important that you know, I'm handling intellectual property. I'm handling contract information. How do I best protect this information? What happens if this information goes to unauthorized users? So the first step is doing a data discovery to know what kind of information you have so that you design robust security policies. So next measure is implement robust cybersecurity policies to ensure that based on the discovery of the information you have, the information practices you're putting in place, the policies, who accesses what information, also are inclined to the data that you have. Another key practice that you need to have, and this is very critical, is awareness, cybersecurity awareness. You can have all the best policies, you can have all the best implementations, but if the people you're working with, the people handling the information, are not aware of the cyber threats they are likely to face, how sensitive the information they have, and the practices they need to follow, then everything else is going to go down. So it is important that you have continuous awareness training for your staff, continuous awareness training of the people that you work with. Even if it is a vendor, even if it is a contractor, ensure that you give them a level of awareness. Another practice that we need to have in place is monitoring of user activity. It is important that you monitor what people are using the access given to them for, so that you don't take it for granted. I could have done something wrong in the configuration, but once you do the monitoring, you're able to know that this particular configuration is right or wrong. And I am not saying we monitor to infringe on people's rights, but we are monitoring basically for use of the information we have in a correct way. Ensure that all our workstations, servers, and devices are secure. Let's have antivirus installed. Let's ensure we're running the latest antivirus. We are running the latest firmware. Regularly update the systems and ensure that wherever there is access to company information, it is only accessible to secure devices. And then authentication and authorization. It is important that you only give people information that is needed to do their work. In cybersecurity, we call it the least privilege principle. My work doesn't involve human resource. Why should I have access to human resource records? I'm an IT person. What business do I have with the financial records? So it's important that we do authentication and authorization. Authorize people to access and use only information that they need to do their work. And then this authorization and authentication should be backed by passwords, so that we have an extra layer of security. Ensure that we have a good password management practice in place, and then everyone is told and taught about the importance of ensuring that their passwords are limited to them, because at the end of the day, if you give me your password, all the operations I do are for you and on your behalf. So it's important that we do not misuse the authentication and authorization that we are given. Ensure that we have in place antivirus and anti-malware on all our computing devices. And then we all do this, but then we cannot have 100% security. So it is important that we have an incident response plan. In case an incident happens, what do you do? How do you remedy the situation? So it is important that as an organization, you have a way to quickly contain the situation and be able to manage the outcome. So you need to have an incident response plan that tells people how do we detect, how do we contain, notify, recover, and then carry out an post-incident analysis to ensure that something of a kind does not happen again. So it is important that we have in place incident response plans. I know we put different security measures, but you can't be 100%. If an incident happens, you need to let people know this has happened, we are managing in a way A, B, C, D, and then analyze what happened prior. How was our security broken, so that you're able to continue fixing and ensuring that you have better security and such incidents don't have to happen again. When we begin to talk cybersecurity, we can speak for a day. I got a notification that we're running out of time, but precisely we have covered a little bit of basics for us to look into our practices. We know what cybersecurity is. We need to know what to do, why it is important for us to secure our systems, and some of the best practices that we can have in place to ensure that our operations are secure. Thank you.
Thank you very much, Mr. Mugabe. A very practical presentation. I am extremely privileged and obviously immensely honored that I have been able to moderate first-class presentations from industry leaders, both from the private practice, but also from the regulators. So thank you very much, Mr. Mugabe. I'd just like to say that if any personally identifiable information or PII was disclosed, it was with your valid consent, having shared that information on email. I think it meets the requirements of consent under Section 7 of the Data Protection and Privacy Act and the definition section as certain. So I'm hoping that since we have the regulator here, I am not prosecuted for the sharing of the information. But having said that, I think you've made very critical points about the importance of understanding, one, the type of data that is being collected, and then designing a security system that is commensurate to the risk that comes from that may come from the exposure of that data or the unlawful access to that data. You also pointed out the importance of an incident response plan, and you explained to us the fundamentals of what cybersecurity is. I think one of the most outstanding things you mentioned was some of the risks that an organization may face. For instance, you've allowed employees to use their work emails on their mobile phones and personal laptops, and if that laptop is stolen and they have access to the entire email database, they work through your system. It reminded me of one of the case studies we had done, which actually was a decision that went to the United States Court of Appeals, the case of Beck versus McDonald, where a laptop was stolen of an employee that had unencrypted personal information of patients in a retirement veterans home. And because of that, they were able to access sensitive health information, and the organization was eventually found liable. So just to make the point that, again, some things might appear simple, like you're allowing people to access their emails even when they're at home, but they can present real risks if people who have malicious intent access that information. Having said that, we're going to move into a brief panel discussion. I think it will be the shortest panel discussion in the history of Law Society events, because it will not last more than 25 minutes. Each panelist will address one question. One of the questions is coming from the audience, which was already shared, and I would like to invite the panelists to take up their seats such that we can each address a question. When you address the question, I encourage the panelists to also share their parting words with the audience. I think it has been a very, very excellent panel that has given us insights. I could say this is a Privacy 101 course. I had to study privacy from the University of Michigan in the US, but we have gotten even better information here from industry leaders. So the first question will go to the keynote speaker, Mr. Berikuja, who is also the acting director for the Personal Data Protection Office of Uganda. And this came from our audience, but it's related to one of the questions I actually had planned to ask you. What advice can you give to young lawyers? There are a number of lawyers who, LDC now has a capacity of close to 2,500. They are graduating. We have young lawyers who have not practiced for more than 5 years. They are interested in data protection and privacy. What kind of courses should they undertake? I know some of them are on your CV. What courses should they undertake, and how can they begin to brand themselves as data protection lawyers. If you could address that and also share your parting shots with the audience, that would be very much appreciated. Mr. Biri Kujja.
Thank you, Mr. Basoga. So that's a valid question. It's one which I had myself before I started this journey of undertaking, specializing in data protection and privacy. Number one, young lawyers have an opportunity which we didn't have at the time when I started practicing, is that within the Uganda Law Society, they have clusters. Join the ICT cluster of Uganda Law Society. A lot is going on. We always actually engage them as PDPO on the events that we have, documents to review, proposals to undertake in any of the work that we do. So if you're part of that cluster, it's a lot easier. But it's not just the cluster of Uganda Law Society that you can join for professionals. There is also an association of data protection officers within Uganda. I encourage you, and good enough, one of the people who are part of that association is part of this panel, Ms. Among. So you can reach out and join those, because when you interact with other professionals, they're able to tell you what you need to focus on, the rhythm or the heartbeat of what's happening in the country and elsewhere. But beyond the associations, which are national, there is an international one, the International Association of Privacy Professionals. You don't need to be certified to join, so you can join and become a member. There is a lot more you can learn. Then you can become certified as well. The importance of certification is that it gives you a hands-on skill. What I did, there is the certification, what we call the WAT, the Knowledge Certified Information Privacy Professional. There is none for Africa, but that of Europe, you can undertake it because it's based on the GDPR, which is the global standard. And then there is one of management, which shows you how to go about with your daily job as a data protection officer. But also I encourage them to write. That's another way of standing out. You can write on a particular topic, decisions in courts of law around privacy, but also as PDPO, we have open doors. We have webinars where we invite individuals to talk about certain areas. You can reach out to us, info@pdpo.go.ug, and we give you that. So those are just some of the ways through which a young lawyer can start this privacy journey and getting the skill set. Thank you.
Thank you very much, Mr. Biri Kujja. I think you've given very practical advice on the different organizations and associations and the ways one can put to paper or practice privacy. Thank you very much. The next question will be going to Ms. Among. Again, thank you for your discussion. The audience would appreciate if you could comment on, the role that cross-disciplinary collaboration, for instance, even on this table, we have an information technology professional. And it is not unusual, even when law firms are bidding for work, it is now almost required that they have to have, a cybersecurity professional and information technology professional. Can you comment on what role cross-disciplinary collaboration, especially with IT professionals, can play in enhancing client support?
Thank you, Joel. So, focusing on the IT professionals, I'll just also add in compliance and risk. Yes, because many times people think it's obvious that lawyers can actually ably provide compliance and risk management without upskilling. So looking at IT professionals, compliance and risk, I would say starting with the IT professionals, we see a lot of technological advancements. He talked about some of the products that exist on the market, even AI solutions that exist on the market. It's important that we be able to work within these circles There are different bodies, first of all, where we can be able to be members, even if it's not members formally. There can be a level of affiliation, and I gave an example of FITSPA. And then, of course, other industry bodies like, let's say, CRB Association, Uganda Bankers Association. When you interact within these bodies, you're able to understand the typical market that you're serving, and then it helps you, or it positions you in such a way that your collaborations that you're driving, even with the parties within those bodies, could be FITSPA, you're able to know what you're looking out for and the value that they can bring, and how that value can translate to better, more value proposition or offering value to your customers. So we're looking at things like streamlining your processes. I'm sure some law firms, it's still the usual things that we've always done, or you have a way of doing processes, how you're filing your information, how you're handling, let's say, company secretarial matters, your filing, how is your filing happening, how are you recording things, how are you registering customers that you're bringing in, how are you contracting. So as opposed to doing things that, you know, are long processed and make your turnaround times long, and there is room for error, and basically there are no operational efficiencies, you can be able to partner with IT professionals to be able to identify particular products or services that can be offered to help make your processes and systems, to streamline them basically. The other is to be able to manage elements around cybersecurity. He mentioned that. So most of the information, I understand most of the information security officers also work closely with the departments in legal, compliance, and risk. So as a law firm that is positioned in a place of working with corporate clients, it's important that you're able to also integrate with and work with IT professionals to be able to support you internally, but then also to know how you can be able to work together. It could be collaborations where you're presenting a proposal, where we'll be giving different data protection services, and this is an element that can actually be covered in that proposal that you're giving to customers. So at that point, the collaboration is not only covering aspects within your organization, but how far you're going to make sure that the customer is getting a full package when it comes to data protection services. And then also when it comes to reaching your customers and interacting with your customers, offering solutions, or just keeping in touch and engaging, you can be able to tap into this area of working with different IT firms to come up with solutions that can be able to reach your customers faster, easier, and provide better services. And then we've talked about cybersecurity, but then of course there could be other data security tools, biometrics as you're logging in. How are you taking care of that? How are you able to engage on your premises, and you ensure that security is actually taken care of? There are so many other things. Could be that you're advising your clients on a typical project. Could be a merger and acquisition, and there are particular areas around software or things that are involving IT, and you need a specialist to be able to be part of that project. That could be a good area for you to be able to collaborate. And as I conclude, I mentioned in my presentation, the era we are in it's just not about a person working in isolation. As law firms, as lawyers, we need to get out of where we are as just lawyers and be able to work with different sectors to be able to leverage and also tap into the different opportunities that are presented to us, but then also to maximize on resources that the different parties hold without you having to invest so much to get those things coming to you. Thank you.
Thank you very much, Ms. Among. And I really agree with you. I think there's an old English saying, I think about 400 years old, that no man is an island. So, you know, and that means that we have to collaborate with others. And I think it's important to always, you know, incorporate IT professionals in these conversations, because most time they know. For instance, there was an incident I had with one of my friends' workplace where, you know, they were able to access his email remotely, And when I engaged the IT professional that we work with, he told me there is a way that you can make sure that the emails can only be accessed on devices stationed at the farm, and restricting only a few people to access those emails remotely. Although the increasing role of the lawyer requires us to be available 24 hours, how do you mitigate those issues? So thank you for pointing advocates to some of the places they can access to be able to have these interactions. Thank you very much, Ms. Among. And I think our next question goes to Mr. Opio. You know, a while back when I was in Washington, I attended the Privacy Scholars Conference, and one of the hot topics was consent. Is consent really the best way to protect data subjects? You know, because autonomy is one of the incentives and rationales for privacy protections, there's an argument to be made, obviously, that consent, people should consent, but do people read the terms of consent? You know, they go on the website, there are all these privacy cookies that say, you know, sign up to use and you consent to us sharing. People don't, some people have argued that most people don't read consent, and therefore consent from both an academic and practical perspective has been questioned. You know, especially when data subjects rarely understand privacy terms. But can you address us on what the real role of consent is in compliance?
Yes, thank you very much, Joel, for the question. And basically, if you look at the Data Protection Act generally, and just to summarize it, I would say that it's aimed at giving data subjects control over their personal information generally. And if you look further at the fact that consent is one of the lawful bases for the collection of personal data, so you have to have a legal basis, and one of them is consent. And then if you also look at the definition of consent itself, it has 4 components that I consider very important. If you look at the definition, for example, it says consent is a freely given, specific, informed, and unambiguous indication of a data subject's right to wish to collect personal data about them. So if you look at that definition alone, you'll see that the main object of the definition itself is intended at giving the data subject control over their personal data in terms of allowing an entity or an individual to collect the personal data and go ahead and use it for a specific purpose, and also at some point to withdraw the consent, which will stop the processing, the process of processing or whatever use that information has been put to. So I think it basically implies real choice and control that a data subject has over their personal data. And then for the part of data subjects not being able to understand terms that are provided for example, in the data protection policies, it all goes back to the organization to make sure that it has a data protection policy or a privacy policy that's so simple and easy for anyone to understand without technical terms and so on. So you realize that most organizations have very lengthy, even sometimes I don't read, honestly. They're so long and it will require you to sit down and read like you're preparing for an exam or something. But if it can be broken down into important subtopics that addresses the issues, that addresses the issues that the Data Protection Act, because the Data Protection Act also has guides on what should be contained in a privacy policy or data protection policy. So if you stick to those, you definitely have a brief data protection policy that will get the consent that will eventually acquire a valid consent from the data subject. Yes, so I think that answers the question. And then lastly, on the parting shot, I think data protection is still a growing area, and we should get it when it's still hot. You know, someone says, strike the iron when it's still hot. So it's very important that lawyers take on this opportunity, because every client that comes to you is actually a potential client in terms of data protection for various, compliance, litigation, everything, especially the corporate clients. We should try maybe to write to them and inform them, because most organizations actually don't know about the implications of the law until they read in the newspapers or see on social media that there is an entity or a director that has been arrested or fined or something like that. Most of them don't know about the presence of this law. So we should take it upon ourselves to inform our clients, because you never know. Just like the previous speaker had said about selling the idea to clients. Sell the idea, sell the idea, sell the idea. You never know. It will increase your business portfolio also. So thank you very much, and yeah, I'm happy to be here once again.
Thank you very much, Mr. Okpio, for your answer. Especially I think it was quite on point. Especially, we may question whether a law is good or not, but the current legal regime is heavily centered on consent, and I think if there is no consent that you're getting when you are receiving data, especially even sensitive data, and then you are sharing it with third parties. We've had investigations where reports, from NITA and the PDPO have cautioned from unlawful access to information, but also sharing with third-party marketing agencies without definite consent. So thank you for reiterating that and for your parting shots. And our last question goes to Mr. Mugabe, who in some parts of the world, like where we are in East Africa, the last speaker usually is the president, or we can presuppose that they are extremely special. So maybe we should attach a lot of importance to the fact that you are giving your remarks last, although the head of your institution is also here, so that makes for an oxymoron. That notwithstanding, I'd like to ask, you mentioned a lot of things, assessing the kind of data that you are collecting and then designing a system that mitigates the risk. I'd like you to comment on, a lot of law firms, I have, from practicing in Uganda and traveling in other countries, I've interviewed with lawyers in Uganda, and some of them don't have even a cybersecurity policy. It's a matter of they run some of the law firms on open access accounts, Gmail accounts, and I find that to be interesting. I would like you to comment on how can law firms assess their cybersecurity posture, and how should training be embedded in law firm culture? Where should they look if they want to get someone to train them, especially a cybersecurity person, to open up their minds on these issues? If you could comment on that and perhaps share your parting shots, that would be greatly appreciated.
Thank you, Joel. I must say that is a very critical issue, affecting not only law firms, but quite a number of organizations who do not regard cybersecurity as a key issue. And this is simply because most of them believe you're only sensitive to security if you're running with computers and the like. And as you know, the adoption and use of computers in many operations in Uganda is still at takeoff. So quite many people are still low on that bit. But then it takes a bit of legal frameworks like the one we're implementing, the Data Protection and Privacy Law, which puts across certain key requirements whereby in your practice you're going to be required to comply with particular laws. For example, if the Data Protection Law requires that one, you register with the Personal Data Protection Office. And in registering with the Personal Data Protection Office, some of the things that we ask you to provide is how you handle security of the data that you collect, all processed within your operations. So with such implementation of legal frameworks, I believe it's going to up the uptake and appreciation of cybersecurity. Again, efforts like this, where we stand and talk to people about the importance and value of cybersecurity, are very critical. I believe after a session like this, the appreciation of cybersecurity should be better. And then when it gets to assessing the security posture of different organizations, different law firms in terms of cybersecurity, I will go back to what Barbara earlier on talked about, collaboration. It's important that you collaborate with different people in different professions. You're a lawyer, you need to work with the IT people, you need to work with the finance. So it's important that there is involvement and engagement of the IT professionals to assist in assessment of the cybersecurity posture. Let's think security. Let's not wait for things to happen and then we have to run back to close the gaps. As parting ways, I will emphasize the issue of collaboration, work with the cybersecurity personnel that are out there. In your introduction, you said it's important for every law firm to have a cybersecurity person that you engage. It's important that you have that particular person that you engage to help you understand. I know there might not be that many, but for someone who is listening in now, I'm sure you're listening to one, so you have a starting point. Thank you.
Thank you very much, Mr. Mugabe, for that specific answer. There's just one last question that a member of our online audience has asked, which is, very fascinating question. The anonymous person asks, my wedding is going to have cameras and videography. Must I get consent from my guests because I intend to post some content on my WhatsApp profile? How far does this consent go? Is it enough to notify my guests that the event is recorded and they should not attend if they do not want to be recorded? I don't know, Mr. Opio, would you like to comment on this in a minute or two?
Yes, you are right. That's very interesting practical question. Yeah, so I think once you decide to organize a wedding and go ahead and intend to take photographs as well as videos, you bring yourself within the scope of the data that you have and you must therefore acquire the consent of the data subjects. This will therefore mean that as the person that has organized this wedding, you need to inform the data. Yes, I think you will have to find ways of separating the people that have consented and those that have not consented. For example, you can maybe give them wristbands so that whenever you see someone who has a wristband on their hand, you know that this person has consented, and you can take their photographs and later on use it for further sharing because they have consented. And then if someone has no wristband, then you know that this one has no wristband and they don't consent to the collection. Or you can maybe put them in different groups. That is kind of inconveniencing, but you can put the photography side and the no photography side, so that those who consent expressly to their photographs being taken can go to one side, and those that don't consent go to the other side. But still, the fact is that you have to get their consent, and they should know what their personal data is going to be collected for. Yes. I think, yeah, thank you.
I'm just going to add something. I attended a very interesting event. So when I saw that question, I laughed. I attended a social event, and what they had done, they had put up a privacy notice. So the way you enter into an event, and there is a photo booth. So they put a privacy notice letting people know that they will be taking pictures and the purpose for the pictures. And if people were not, agreeable to that, they could indicate so, to one of the people that were in charge of the event. So I think that could be another way. Beck and the team can confirm. But yeah, I saw privacy notice, the typical one you would see on a website or something. Yeah.
Thank you very much. It's a very good question. Unfortunately, all good things must come to an end. I think William Shakespeare says that all the world's a stage, and the men and women all have their time. And so while the panelists today have made first-class submissions, this discussion must come to an end. And so I would like to firstly thank the keynote speaker, Mr. Birikuja Baker, the acting director for the Personal Data Protection Office of Uganda. Thank you very much for making the time to share from your wealth of experience, but also as at the helm of the principal regulator for data protection. Thank you very much. Would also like to thank Mr. Stephen Mugabe, who is an IT professional, but also the manager for data protection affairs at the Personal Data Protection Office, for offering practical insights that have expanded our very limited legal knowledge. Lawyers often claim to know much, but most times when they interact with other professionals like IT professionals, doctors, there's always a lot to learn. So thank you very much, Mr. Mugabe. And thank you also very much, Ms. Among, for your detailed submission that draws from your wealth of experience from both the financial services sector, but also some of the illustrious experience you've had in this space. And again, thank you, Mr. Opio, for answering the questions, but also telling us in practical terms what these obligations under the Data Protection and Privacy Act mean for law firms. I have had the distinct honor of presiding over this training. For those of you who had not interacted with me, my name is Joel Basoga. I practice and I head the technology, media, and telecommunications practice at H&G Advocates, Uganda's oldest law firm, where we practice in data and several other overlapping areas. So, as parting shots, really, we should remember as advocates, but also as lawyers, that we have obligations to comply with the Data Protection and Privacy Act. There are various opportunities that have been highlighted by the panelists, but also we must note the importance of the best cybersecurity practices being implemented. And as we end, I just want to comment on the the question that came in from the anonymous member of the online audience about the wedding. And, one approach, obviously, and two approaches actually were given by two of our panelists. I also think, should you be sued, there might be a valid defense of, is there a reasonable expectation of privacy when you go for a wedding? I have studied a number of cases, and they hinge a lot on, when you have gone for a wedding, which is like going for a political rally, are you now going to begin to draw the line? So I do understand, again, but this is subject to the layers of advice. I'm saying in the alternative, as writing legal submissions in this case, I would advise you first have consent, put a privacy notice in the event that someone still sues, because that has not stopped data subjects. Even when they've signed some vague consent, they've brought suits, and courts have agreed with them. I think that perhaps we need to test that defense that has been applied in terms of the common law appreciation of privacy when you go to a wedding. Is there a legitimate expectation of privacy? I think that's a question I will leave to our audience to think about. Otherwise, thank you very much for your time. It's been an extreme honor to be able to facilitate this discussion, and we will stay in touch. Thank you to the Uganda Law Society the staff that have organized this, to the Law Council within the Uganda Law Society for organizing this event and putting together a panel of esteemed thought leaders and practitioners. For me, it was an extreme honor. And thank you to our audience for staying through. We've had a consistent number of people who have not jumped off the call. And thank you to the people, DM Events, who have been behind setting up the infrastructure for this event. We appreciate your diligence, without which this event would not have been smooth. Thank you very much, and for God and my country.